It was an amazing time.
Are you certain?
Hi, guys. I hope everybody's doing well. I think everybody's been waiting for this for a while. I think you'll be excited to hear that Jim, Happily Angry Lawyer, and Tiffany, the Fit Lawyer ATL, have filed a motion to vacate void sentence. If you remember a few weeks ago now, there was a motion that they filed to vacate the sentence. It was granted, and Whitaker, in my opinion, ignored everything else that was argued in that motion that we looked at then and just said, all right, I'm going to resentence Antonio Sledge to 20 years for the first count because the other thing was kind of funky. Well, there's some issues with how she did that, and we're going to get into them in detail, but just know that if you're here just for the short of it, there's a lot, guys, and we have to keep fighting for this. Mounk Tounk has been in solitary confinement. Like, how and why? We have somebody that they get a plea, he goes straight to probation. His probation's revoked because the state moved to revoke his probation after he didn't testify the way they wanted him to. And somehow he's being held since October. He's been held, and for a good portion of that time, he's been in solitary confinement. There's a lot in here. There's a lot of issues with the sentencing. We're going to go through this. Looks crazy because it says 599 pages. That's because they've attached transcripts and other filings. It's about 30 pages for this motion. We're going to look at all of the relevant exhibits as well as some clips. We have some clips lined up to play what the initial plea hearing was like. But again, I know a lot of people don't make it all the way through the video. So to front load this, if you guys go back to the plea hearing, the law and crime plea hearing, I'm going to drop the link in the chat. I'll have to put it in the description. Let's see. This takes us all the way back like 3 years ago. This should be a time-stamped link. We're going to play it through the stream. But if you guys go find it on your own, I want you to be aware of two things about that plea hearing. In the portion that law and crime, the streams caught, they only catch the first half of it. We heard a little bit in the first motion to vacate, you know, this isn't going to work, Glanville. His court assistant told him, this isn't going to work. We have to restructure this. And Glanville's like, you're right. We have to restructure it for this to work. So Love asks for permission for all the parties to confer. That's where the law and crime stream ends. But Jim, Tiffany, they looked at the transcript. They saw what happened with that, and it's going to come into play in this motion. But just know that that clip that a lot of us watched of the plea hearing, it's like 30 minutes, isn't actually the complete, and it isn't the end resolution. It isn't the plea agreement that he actually signs. And yet, what's introduced to him in that first portion before they have to redo it, the first plea agreement, it ends up getting amended. So there's a different plea agreement that's actually accepted and finalized that day. Well, we have another clip. We're going to get to from day 124 of the YSL trial. Dropping that link in the chat here. Where Adrian Love, Mounk Tounk gets on the stand, and Adrian Love is trying to introduce Exhibit 1AS. 1AS was the original plea agreement, not the amended one. So there's going to be a lot of document names, again, different points in time, right? Because we have the plea hearing all the way back in 2022, oddly, right after the Christmas holiday, and all the way moving forward to October of 2024 when the state motion to revoke Mounk Tounk's probation. We've got these time jumps. So we'll get through it. I think they did a great job writing this, so I think we'll be able to follow it just fine. But if you guys get confused, you let me know. And Jim is here. Jim, I would love for you to come up once we do the reading. I think we can watch those clips with you up here if you want, because you can point out and say, that's important. But we'll get through this reading, and I'm sure Jim will have thoughts. If he's willing to share them, he's more than welcome. You'll also notice a pinned chat and a banner with information for Jim's Cash App and his Zelle. He did not ask me to put these things here. I didn't really consult with him on it. I just decided to put it there. He is doing this work pro bono. So if you guys want to support him, I strongly, 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 strongly recommend it and appreciate it. Super big shout out to BigBabyJane for being a member for 10 months and saying, oh, how I've missed you guys so much. How this will work, you guys, if you guys want to send a Cash App or Zelle to Jim and treat it like a super chat, I will try to like peek over to the chat and pin the comments and treat them like super chats. So if you donate something to Jim, put like a $sign before your chat and I'll look to try to start and we'll get it shouted out. Jim, let me get through this reading unless you decide you want to come on earlier. But I think with the two of us reading, I don't think we'd get very far. So plus, maybe Miss Adams, maybe Tiffany would advise getting through the reading and getting you on. So guys, here we go. We have State of Georgia versus Antonio Sledge. And you notice this is spelled correctly? This is progress here, you guys. We're doing good. We are doing well. So comes now Antonio Sledge by and through his undersigned counsel and respectfully moves the court to vacate the sentence on count 1, pronounced on April 28th, 2025, or in the alternative, his entire sentence pronounced on December 28th, 2022, or in the alternative, the 5-year term of incarceration imposed by the court on October 18th, 2024, in connection with its revocation of Mr. Sledge's probation on account of an unspecified violation. So remember, the state moved. He violated the terms, the special conditions of his probation. Well, we're going to get into that because there's some issues. In support of said motion, Mr. Sledge shows this honorable court the following. Statement of facts. 1. Mr. Sledge's April 23rd, 2025 motion to vacate. So this is the most recent thing that we've looked at. On April 23rd, 2025, Mr. Sledge filed his motion to vacate void sentence. We're going to call that prior motion. Attached as Exhibit A. The prior motion first argued that the sentence imposed on count 30 was void because Mr. Sledge was sentenced under OCGA 131B to 15 years. Where the maximum sentence prescribed by law was at most 10 years. Proceeding from that conclusion that the sentence on count 30 was void, the prior motion argued that the court should vacate Mr. Sledge's entire sentence because it was imposed pursuant to a package deal. This is linked in the description if you want to go and get a rewind on that first motion. Were the court to apply the package deal concept and vacate Mr. Sledge's entire sentence, the revoked portion, which we're going to call revocation sentence, would, of course, be vacated in the process. Even if this were not the case, the revocation sentence would still require vacatur because the court cannot revoke probation based on the violation of conditions set forth in a void sentence. All right, so we got that. I think that one was easy to get through. So 2, the court's April 28th, 2025 vacatur order and amended disposition. So we're going to be looking at, this is Judge Whitaker here. On April 28th, 2025, the court issued its order granting defendant's motion to vacate void sentence on count 30, calling that the vacatur order. Attached as Exhibit B. The court concurrently entered an amended final disposition, the amended disposition, attached as Exhibit C. This court did not address the argument relating to the package deal issue. Mr. Sledge files this motion, re-raising that issue. In addition, the court erred in its resentencing on April 28th, 2025. So this is saying Whitaker messed up, as the court increased the length of Mr. Sledge's sentence on count 1. Specifically, on page 2 of the amended disposition, the court placed an asterisk, referring to the total 20-year sentence, which clarified that the 20-year sentence was to be probated, quote, aside from the first 5 years that have previously been revoked on October 18th, 2024. We've got a footnote here. The court's vacatur order uses the, quote, first 5 years language 3 times, including, so not a scrivener's error, right? Including the final sentence, which reads with emphasis added, defendant's request to vacate his October 18th, 2024 revocation of the first 5 years of his probation is denied. So then let's see. However, Mr. Sledge had already been serving his sentence on probation for at least 660 days as of October 18th, 2024, in addition to approximately 215 days in the Fulton County Jail. So 2/3 of a year in custody 660 days, just shy of 2 years served on probation already of the first sentence from his plea deal, his initial sentencing after the plea. And we're going to go down and look at these exhibits in a second. You're going to see that was not taken into account when Whitaker resentenced. Thus, the court's October 18th, 2024 revocation order, the revocation order, did not revoke the first 5 years of his sentence, as stated in the vacator order and the amended disposition. In essence, the amended disposition pushed back the start date of the 15-year sentence on count 1 from December 28th, 2022 to October 18th, 2024. So there's multiple layers here, taking it a little bit at a time. We're leaving off here on page 3. We're going to go all the way down and find Exhibit A. This is 600 pages, you guys. So we might have to do a lot of, here we go, Exhibit A. Okay, this was the first motion. We need Exhibit B. I want to show you guys Judge Whitaker's order. Let's see. Oh gosh, where is it? Let's see. Oh my God, we're going to do so much scrolling today, chat. Because these indictments are long. There's a transcript in here that's really long. It's the transcript of the plea hearing, though, so we'll get to see the second half that Law and Crime didn't capture. Actually, can I go to a page view? Would that be easier? The number of times we've seen some of these pictures from this indictment over like the year and a half that we've spent together, chat. All right, that's the transcript. Ah, here we go. This is what I want. So, let's see. So you can see this is the April 28th. This is the final disposition. You've got his 2 counts here. Count 1, sentence is 15 years probation. Count 30, 5 years probation. Now look at this here. It says the defendant is sentenced for a total of 20 years, with the first blank to be served in confinement and the remainder to be served on probation, or X this to be served on probation. But this part's blank. The defendant is to receive credit for time served in custody. It's just blank. It's just blank. And let me, big shout out to Tia. Tia sent in a CashApp to help Jim, supporting the pro bono efforts. Big thank you to Tia. Everyone show some W's in the chat for Tia. But isn't this a little crazy that this is blank? So in the future, if somebody isn't doing their due diligence and they just rely on the paperwork, one might assume that Antonio Sledge has served nothing, has served no time for any of these sentences, void or not. It just looks all blank. And then we get here, and this is one of the mentions here of this, aside from the first 5 years. The above sentence may be served on probation provided the defendant shall comply with the conditions of probation imposed by the court as part of this sentence. So we get an asterisk here. That's the aside from the first 5 years that have previously been revoked on October 18th, 2024. So we're going to hear more. We're going to hear more about this, but I thought it'd be good to see it. And notice here, we have special conditions of probation, and they're setting the terms as follows. And then now we have special conditions of the sentence indented here, included under this header, special conditions of probation, which was missing from the first disposition back in 2022. There's also no double negative. If you guys remember, the you shall not possess no guns, I think was the wording, that is fixed here. You shall not commit no criminal acts is fixed, no more double negative. So just a little look there. And shout out to the attention to detail, right? Because I just wonder how many other times mistakes like this are made in somebody's sentencing and their plea deals, and it just goes under the radar. So huge shout out to Jim, huge shout out to Tiffany there for their attention to detail, and not shout out to Fulton County or Judge Whitaker. We were here. So 3, relevant factual and procedural history of the case. Mr. Sledge was originally indicted, you guys know this date, May 9th, 2022. Under case number, we're going to say 73 is the original indictment. The original indictment is attached as Exhibit D, which we just scrolled through. The original indictment charged Mr. Sledge in count 1 with conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, and in count 30 with possession of a firearm by convicted felon. That's 131. On August 5th, 2022, the District Attorney, Fonnie T. Willis, re-indicted the case under, this is 72, the re-indictment. The re-indictment is attached. With respect to Mr. Sledge, the caption of the re-indictment was not revised from that of the original indictment. As in the original indictment, the re-indictment's caption stated that count 1 charged conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, and count 30 charged possession of a firearm by a convicted felon. Again, 131. 131. So, plea negotiations commence on or before November 30th, 2022 with Attorney Love. I notice there's no first name here. It's just Attorney Love representing the state and Mr. Derek Wright representing Mr. Sledge. The next day, December 1st, 2022, the state filed its motion in limine on the substance of the indictment, demonstrating the state's awareness of the discrepancies in the re-indictment. So, there's an issue. They're at least showing that they're aware of it in some part. On December 9th, 2022, the state filed its notice in aggravation and intent to seek recidivist punishment. Now, pay attention to these dates. This is December. This is December of 2022. We all know for multiple individuals that were named in this indictment had been asking for, give me a bond hearing, maybe even asking for a deal and being denied one, but certainly bond was being denied for multiple people. And then December's rolling around, and all of a sudden, there was like this magical day where everybody that was too scary and too dangerous to be let out on bail was suddenly given a plea deal where they go straight to probation. But right before they do that, they're filing all these notices that are, an aggravating factor is something that would bump your sentencing up and closer towards the maximum. That's more bargaining room for the state. Instead of facing 10 years, you're facing 20. Or instead of possibly having your sentence run at the same time, they have to be consecutive. So that makes you're looking at more time because of this. Oh, well. So they're making sure they have all of their T's crossed and I's dotted when it comes to something that would give them additional leverage in plea negotiations. They're doing all this work, even though they don't do their other homework. So, in which the state noticed its intent to seek punishment under 17-10-7A, which would require that Mr. Sledge be sentenced to the maximum permissible term of sentence. This is the game. Continuing its coercive course of conduct, and I love the language here, just call it out. The state did not make an offer to Mr. Sledge until December 27th, 2022, the evening before Mr. Sledge's scheduled guilty plea hearing. Now, this December 27 date is also important, right? Because the plea hearing is actually going to be on the 28th. But do you guys remember all of the Antonio Sledge, Derek Wright, attorney Derek Wright, Adrian Love, they were emailing back and forth. There were other versions of the agreement. Just keep that in mind. So, the evening before his scheduled guilty plea. Then the transcript of the plea hearing, which is attached as Exhibit F. We've got that below. We'll look at that later. Less than 24 hours later, on December 28th, Mr. Sledge and the state entered into a negotiated plea agreement. We're calling this the first plea agreement. We've got a footnote. The first plea agreement is marked as 1AS and was referred to as such during the trial. So remember, we talked about that earlier. This is the same plea agreement that Adrian Love asked Antonio Sledge about when he first took the stand. This is the plea agreement she asked him about and got admitted into evidence as the plea agreement, as far as anyone knew. The first plea agreement addressed and resolved both counts 1 and 30 as a package deal. The first plea agreement is attached as Exhibit G. The state presented to the sentencing court the terms of the negotiated sentence detailed in the first plea agreement. And those are transcripts. It's included below. And I think, Jim, when you get on here, we can look at that part of the transcript. Notably, the first plea agreement called for sentencing to be withheld on count 30 until the completion of the initial trial under the reindictment. By calling for sentencing to be withheld on count 30, the first plea agreement required Mr. Sledge to be released with neither a sentence nor a bond in place as to count 30. The sentencing court, in consultation with its staff, so this is Glanville days, determined that Mr. Sledge could not be released in such a manner. Accordingly, the sentencing court properly rejected the first plea agreement. Rejected the first plea agreement. Rejected 1AS. It's rejected, and somehow at trial, that's what's being introduced. They observed at the first plea agreement, quote, "You have one of a couple options. You just can't do it this way." The sentencing court then recessed in place. And again, this is where the stream cuts out. There's no stream beyond this point, giving the state and attorney Wright an opportunity to negotiate and obviate the problematic terms to the satisfaction of the sentencing court and its staff. The parties entered into a new negotiated plea agreement, the adopted plea agreement, that's what we're going to call it. And Attorney Love proceeded to describe certain of its terms to the sentencing court. The adopted plea agreement was never reduced to writing. The most significant change reflected in the adopted plea agreement relates to the sentencing on count 30. Instead of withholding sentencing on count 30, the adopted plea agreement called for Mr. Sledge to be sentenced immediately. As mandated by 16-11-133, now remember, 133 would be possession of a firearm by a convicted felon during the commission of another felony. Not the language that we saw with 131. So, as mandated by 133, the sentence on count 30 would be 15 years in length and run consecutively. Can't run at the same time to count 1. We've got a footnote here. As previously briefed, the correct charge of count 30, 131, may be run either concurrently with or consecutive to other sentences at the trial court's discretion. We talked about this when we discussed the first motion to vacate the sentence. If someone's offering you a plea deal and you've got 2 charges and the way it's presented to you is, look, if you take this to trial and you get convicted, you could be facing whatever for count 1, and your second count for count 30, if you're led to believe, it's 15 years and it would have to be consecutive. It can't just run at the same time and reduce the total years that you might be facing. Do you think your negotiations or how you might approach a plea negotiation might be a little bit differently? Because if so, that means you're looking at these 2 counts and what's on the table for you as a package deal. So, let's see. Also new to the adopted plea agreement was the state's agreement not to object to the termination of the balance of Mr. Sledge's probation after 10 years. The sentencing court adopted the adopted plea agreement, quote, as tendered and negotiated, and oral pronouncement of sentence consistent with the adopted plea agreement and entirely irreconcilable with the first plea agreement followed. And this is important because remember, all of the hullabaloo that follows in the YSL trial, anything that Paige asked questions about, Whitaker asked questions about, Whitaker steered towards what's in 1AS, the first plea agreement. The sentencing court's rejection of the first plea agreement and acceptance of the adopted plea agreement was confirmed by the sentencing court's December 28, 2022 final disposition, the original disposition, which excerpted and revised certain language from the first plea agreement. Per the canon of construction, expressio unius est exclusio, I feel like I'm doing a Harry Potter spell, alterius. Is this linked? Was this supposed to be a link, Jim? Did you mess up? The chat's going to get out their red pens. The inclusion of one is the exclusion of others. The sentencing court's exerting portions of the language of the first plea agreement proves its rejection of the remaining portions. Now we have a footnote here. It says, notably, the defendant's factual acknowledgments are not among the provisions excerpted and included in the original disposition. So we're missing the factual acknowledgments from the amended. They're not there. They're not there. Among other things, the original disposition directed Mr. Sledge to testify at trial. After Mr. Sledge testified during the first trial on this reindictment, the state filed its motion and petition to revoke probation. This is the revocation petition, which is attached as Exhibit H. And remember, this is October 2024. At the evidentiary hearing, you guys might remember this was Adam Abate that was leading the arguments during that. And I think at the end, Love walked in. She didn't really participate, but she walked in the leather jacket, and everyone was like, oh, is she hiding? That was that hearing. At the evidentiary hearing, the revocation hearing regarding the revocation petition, the court took judicial notice of Mr. Sledge's testimony from trial and heard testimony from an unidentified and unsworn Department of Community Supervision officer. Ultimately, the court ruled that Mr. Sledge, quote, has violated the special conditions of probation as alleged in the petition for revocation. The court then imposed the revocation sentence, revoking 5 years of Mr. Sledge's original 30-year sentence, and ordered that he be reinstated on probation upon release. The revocation order is attached as Exhibit I. So we're going to be moving in. We've got so many more arguments to get into. This isn't even the half of it. And again, last time we said it's kind of like Russian dolls. You got to attack issue by issue. And I don't think that that's an easy thing to do, but they're doing a wonderful, wonderful job with the way they're writing this up. A pause here to see what you guys are saying. Again, super thank you here to Tia for sending over some support over to Jim for his pro bono efforts. Sleepy, good to see you, and thanks for becoming green. Tay Biz, you guys know we love Tay Biz in the building. Says, thanks for covering this, cat. What up, though, Chidat? And free Mounk Tounk. It's going to get worse, you guys. So free Mounk Tounk times 1,000,000. Oh, my goodness. I see Candace hopping in here. It's like we're getting the YSL family back together. And it's crazy because the Atlanta Journal-Constitution, they did a count and they said that from the indictment to the end of trial was 1,128 days. Well, if we end up in a situation where Mounk Tounk, as far as his count 1 and count 30 in this indictment, if we end up finding out that there has not been a proper adjudication of those counts, today would be day 1,149, and the counter would continue. So we heard a few weeks ago, the YSL trial is over with 0 murder convictions. They got a jury verdict returned on 1 gun possession charge. Imagine these news outlets and bug them, pester them, tell them about the Mounk Tounk scenario and what Jim and Tiffany are doing. Imagine if they get to say, the longest trial gets even longer. Just crazy, crazy stuff. Crystal says, has anybody seen Vera? Jim says he should be disbarred. He forgot to put the OCGA before the 133. Oh, my goodness. Yeah, the oops, the whoopsie. Tat Clouds is here, says, oh yeah, baby, she's running in here. Good to see you, Tat Clouds. Let's see. And then, oh, Nisi. Oh, I don't know if I can give you instructions to hear me. Maybe the chat has asked you to refresh. Can someone in the chat type to Nisi to try refreshing? Because I don't think, if she can't hear me, I don't think I'll be very helpful up here. Peter Ortiz, good to see you. Good to see you. I have a question, Peter Ortiz. How can we make Karen Reed responsible for this hot mess? Although, you know what? I feel like you'd be fine blaming Fulton County as usual, because not a surprise for Fulton County to mess up 10 things in a row. Just crazy. Oh my goodness. And I want to see. Yes, so Miss Chocolate says, I'm confused. So did they go off on the wrong one in trial? Basically, yes. And I have those clips. And do you think it would make more sense? We could run that right now, actually. Let's see. I know one of them is my own stream because I use the transcript to find it. So sorry, I'm putting myself on the screen. But let's see. Where was it? Let me find when they put Sledge on the stand. And this is why, if you guys saw, a whole bunch of us started watching this last night. Let me see. Where do they bring him in?
Please situate loud enough so high school, the last grade you completed.
You know, I thought I had it timestamped, but maybe I didn't. So we'll come back to that because I did something wrong in my notes, but I'm pretty sure it was timestamped in my tweet. But yeah, Love gets right in there. She's trying to introduce this exhibit and she says 1AS, and 1AS is the first one that was not accepted. It was rejected. So Miss Chocolate, yes. And I mean, you should be confused, right? That's something that shouldn't be happening. And me personally, my own opinion, I'm not imputing my opinion on anybody else. My opinion is that this is too much to be excused by incompetence. It seems slick. It seems like an okie doke. It seems like an intentional switcheroo that if anyone calls us out on it, we can just say, oh, oops, it was a mistake. And no one will be able to prove otherwise. My personal opinion is that's what that actually was. So, and I think we're going to get to a few more examples of that. So, and then Crystal says, so who wrote this paperwork? So if you mean this motion is Jim and so Happily Angry Lawyer and Tiffany. So Fit Lawyer ATL. So yeah. And Brittany, good to see you, says her accepting testimony from a witness under oath was hella weird. And I think you mean not. Yeah. Yep, exactly. You guys all see it. Peter says, how could this have gone so wrong? It gets worse, Peter. It gets worse. Cardi says, Jim did his big one. Thank you, Jim. Free Mounk Tounk. My goodness. My goodness. Crazy. Wow, are you serious? Sidebar, Kate Aiden says Brian Koberger pleads guilty. Wow. Wow. Pleaded guilty to avoid death penalty. Wow. And thank you, Tia, for relaying the message. What news? Whew. So let's get into this. We're going to do like an argument at a time and then catch in with what you guys are saying to make sure we're all getting it. The other Jim is here, Jim M. Good to see you, Jim. Let's see. Sentences unauthorized by law. This is like common sense, but you've got to make the argument, right? And this is what I said earlier in the stream. I have grave concerns that if they did this many times with one individual in this one indictment, I guess 2 indictments technically, how many other times are there these mistakes that are just simply unauthorized by law? Things that go beyond what the statute allows, things that go beyond sentencing maximums, whatever could make something void, but it just doesn't get noticed. So let's look at what's happening here. In the context of a criminal conviction, a sentence is void if the court imposes punishment that the law does not allow. So we're going to see a lot of cites to Parrott v. State. And this is true even for defendants who plead guilty, because a defendant who knowingly enters into a plea agreement does not waive the right to challenge an illegal and void sentence. So even if I tell you I did it, I accept all responsibility, I agree to what you put on the paper, you can't enter something that's void on its face. Just because you sign a piece of paper, like a void contract, like it reminds me a lot of contract law. Just because it's on a contract doesn't mean it's a legal contract, just because it's on paper and somebody signed it. So same principle, but with bigger impacts here on the criminal side. A sentence entered in a criminal case, which is unauthorized by law, is a nullity and void, and until the court imposes a valid sentence, The criminal defendant stands as though convicted but not sentenced. This is why, although a sentencing court lacks jurisdiction to modify a sentence after the term of court in which the sentence is pronounced, where the original sentence was illegal, the court may resentence at any time. So, another argument here, the court must vacate the amended sentence. So this is Whitaker now. The court must vacate the amended sentence imposed on April 28, 2025 by Judge Whitaker because the amended disposition increased the term of sentence during Mr. Sledge's service thereof. So when we took a look earlier at that exhibit, we saw she didn't notate any credit for time served on the new disposition. Just left it blank. And she put the asterisks in except for the 5 years. And somehow we get to 20 years. So what's the problem with that? Well, we have this quote from Pitts v. State. Once a person has entered upon the execution of his sentence, the court is without power to change it by increasing the punishment. This is because, in the multiple punishment context, the double jeopardy clause of the Fifth Amendment protects the defendant's legitimate expectation of finality in his original sentence. So, now remember, this is different than, say someone wants to do a non-negotiated plea and they think they might get something and the state proposes whatever, the defense counters, and the judge is like, you know what, I'm actually going to do this. The judge suggesting a stricter sentence or stricter terms isn't double jeopardy because it's before everything's agreed upon. But now we're in a situation where we've got a whole separate scenario. This is a separate sentencing action. So a defendant once expected, I'm agreeing to all these terms. That's what I've got. If I violate it, the maximum repercussion I could face would be this. And then suddenly it's resentenced and it's worse. That's why we get into double jeopardy territory. So in Harris v. State, Harris v. State is instructive. In Harris, the defendants were convicted of and sentenced on 2 counts of armed robbery. The defendants subsequently moved to vacate those sentences, arguing that the 2 counts should have merged. The states conceded the point, and the trial court resultantly vacated one of the 2 sentences. However, the court simultaneously increased the term of the sentence on the remaining count from 10 to 20 years. On appeal, the Court of Appeals held that and guys, these are all cases from the Georgia appeals courts, and they're recent. So this isn't a situation, this is great research, very helpful case law, matches the same issues that are being argued here. On appeal, the Court of Appeals held that while a trial court can correct a void sentence at any time, it generally cannot increase a valid sentence once a defendant has begun serving that sentence. As the defendant's original sentence on the remaining count was legal, and the defendants had already begun serving that sentence, the double jeopardy clause prohibited the resentencing. Accordingly, in Harris, the Court of Appeals vacated the amended sentence. In the instant cases discussed above, the amended disposition imposed upon Mr. Sledge a 20-year probated sentence. Quote, aside from the first 5 years that have previously been revoked on October 18th, 2024. Thus, the 5 years of the revocation sentence are the first 5 years of the currently effective 20-year sentence. Per the amended disposition, both began to run on October 18th, 2024. The original disposition imposed a sentence on count 1, running from December 28th, 2022 through December 27th, 2037. As a result of the amended final disposition, so after Page's resentencing, count 1 is now slated to run from October 18th, 2024 through October 17th, 2039. So there you go, an extended sentence. Look, in the most favorable light to the math possible, it's still extended. In sum, the amended final disposition extended the sentence by nearly 2 years, from December 27th, 2037 to October 17th, 2039. Here, as in Harris, Mr. Sledge was sentenced on 2 counts, one of which was subsequently vacated and one of which he continued to serve. The court increased the term of the sentence imposed on the count Mr. Sledge had been serving for years, count 1, when it vacated the void sentence, count 30. So, I don't know if you guys remember the day that Judge Whittaker's order came down, but it was kind of like, to me, it felt like, oh, well, that one's no good. We'll just stack some years onto this other thing and call it gravy. It's all good. We've worked it out, which you can't do. The result reached in Harris, vacater of the Harshen sentence, is the correct result here. This court should vacate the sentence on count 1, pronounced on April 28th, 2025, which is void, for violating the double jeopardy clause. Now, this is my opinion again. I'm going into my own opinions. There's rumors that Whittaker's on the short list for the Georgia Supreme Court. It seems like she might want to go there. Do you think it's a good look if she lets this issue go beyond her courtroom? Is this an issue she's going to want to hand wave off and, oh, go take it to the appeals court? On principle, no judge should want to do that. No judge should waive a double jeopardy issue off to the side for someone else to deal with, especially while someone's in custody. But even for selfish reasons, I think there's a bigger reason. You know, Whittaker, maybe you should have paid a little more attention to detail when you got the first motion to vacate, because she seemed to skip a lot of the arguments that were made in that first motion. Just made thought she was smart enough. Oh, I know what they're going to argue. I see what they're getting at. I get it. Haha, we'll just do this. And she didn't really actually read. She didn't listen. So big oops, big L for Whittaker there. And then let's see. Nem's over here saying K&W gang still furthering the conspiracy. Hold on now. Don't let them add more people to the indictment if they open this thing back up. And Jim with the language too says, good seeing the gang. Happily Angry Lawyer says, LOL, I use your stream to find stuff too. Guys, if you didn't know, and I don't think you can do it on mobile, but on desktop, if you open up a YouTube stream, expand the video description, there's an option at the bottom that says like see transcript, and then you can use Control F or Command F if you're on an Apple computer, and you can search for words and it'll search the sidebar transcript that opens up. It's a really, really, really helpful way to find, those stream videos used to be like 8 hours long. So if you can think of a unique enough keyword that it'll take you, you don't want to search the word it'll take you like a million results. But it's a super, super handy thing to find a particular moment in an 8-hour video. So, and then Peter Ortiz with the super sticker. Huge thank you to Peter Ortiz. Peter Ortiz, drop some booms in the chat for Peter. Always supporting and showing love here. Peter's making it possible for me to build a business I'm building while it's not really in the green on revenue. So huge, huge shout out to Peter Ortiz, always supporting the channel. And great insight and commentary on Fulton County and others. Was it the day, Tay Biz says, was this the day where he said, stop talking to me like I'm your child? I feel like that was the second day he was up there. But I think he had sound bites every day. Sound bites every day. So Angel, he's not getting out quite at this time. Maybe you're talking about Coburg. I also think that's a no. So Whittaker has to consider this motion first, but they're asking specifically for a hearing here. I'm going to get into a separate gripe about how sentencing went down with Whittaker in April. I have a gripe there too. I have a lot of gripes. David, I agree. David, guys, put a 1 in the chat if you agree. I swear all the supposed YSL gang members come off as more professional and ethical than the whole DA's office. I'm gonna put a 1. I'm gonna put a 1 in the chat there myself. Let's see. Oh, it's still not confirmed, the Koberger thing? Okay. Sorry, guys, I'm late to these. It's confirmed that he's expected to take a plea, but it hasn't happened, and until it does. So it seems like there's going to be a hearing where they at least hear the plea, and he has his chance to say yes or no. So you never know. Things could change. It could be reliable now, but he could change his mind between today and tomorrow. So, yeah, there we go, Factual Eye. We will go here. We will go back to our regularly scheduled program. So let's see, we're on 6 here. Mr. Sledge has the right. Oh, this is the gripe. This is the next gripe I had anyway. Mr. Sledge has the right to be present at any sentencing hearing and any amended sentence must be issued in open court. Now, remember, when Judge Whitaker's order came down in April, we had the filing on the docket and we got to read it. Not all hearings are streamed, but what we found out after the fact, I think we'll see. I think they're going to argue what we found out. Trial courts are obligated to permit defendants to be present for their resentencing proceeding and must issue the amended sentence in open court. So from Pittman, a criminal defendant has the right to be present at all critical stages of the proceedings against him. Thus, where a defendant is resentenced or a sentence is amended, the defendant should be allowed to be present. That is because a resentencing proceeding is a critical stage in which a defendant's rights may be lost, privileges may be claimed or waived, or in which the outcome of the case can be substantially affected. Violations of a defendant's right to be present at all resentencing proceedings are presumed prejudicial and are not subject to harmless error review. Now, this is not that common, right? There's the joke, there's the meme in the lawyerly world. I love looking at lawyer memes because it gives me insight on, I'm not a lawyer myself, so seeing memes gives me an insight onto the day-to-day experiences of attorneys. And there's a meme of, oh, you make a really good argument, and the judge is like, great argument. And the next thing they're going to say is, but it's fine. It was harmless. We're not going to change anything. No sanctions for appeals. It was harmless error, so we're not going to reverse any decisions. So to have case law with a strict, they say no. It's going to be presumed prejudicial if you deny a defendant their right to be present at a resentencing proceeding. You can't really toy with this. So they got Taylor v. State here. They got Peterson v. State. Proceedings within the ambit of the right to be present include both resentencing hearings and pronouncements of amended sentences. Such pronouncements must be made in open court. So in Pittman, the trial court held a resentencing hearing attended by the defendant with counsel present. However, the trial court did not issue its amended sentence in open court. Instead, the order was emailed to the parties. As such, the trial court erred, and the Court of Appeals vacated the sentence imposed. Because Pittman had attended his resentencing hearing, the trial court was instructed to simply impose the modified sentence in open court. Now, we're going to come back to argument 7, but we're going to go back down to, what exhibit was that Whitaker gave? Sorry, we're doing the scrolling game again, guys. Unless it's searchable. Is it searchable? No, it's only giving me one result for, no, maybe this is it though. Oh, it worked. Okay. So searching for Tiffany worked. Now, the reason I searched for Tiffany, look at all this, sentencing terms, all of this stuff. And look what we have here. The Honorable Tiffany G. Adams, aka the Fit Lawyer ATL, attorney at law, represented the defendant by, and it's checked off employment. So it's written here. And again, if you were to look at this later on, you would assume they had a hearing. He had counsel present because it's marked here that Tiffany Adams was present. Whitaker issued this from the bench. There wasn't a hearing here. Tiffany Adams wasn't present. Antonio Sledge wasn't present. He wasn't invited to be present. So, but again, if you look at this, if you rely on this documentation, if you don't have the surrounding context, you wouldn't even notice that this could have been an issue. So I think that's a huge problem there. Just crazy. Now I've got to find my way all the way back up, you guys. We're time traveling. Oh my goodness. Can you imagine if this was 599 pages of motion, of argument? That'd be a very long stream, chat. We would make it work. Okay. I think we're getting closer. Okay, so here we are. We are back to argument 7. uh, big shout out here also. Tay Biz making the chat green again, growing the gang. Super appreciative, Tay Biz. Make sure you're saying thank you if you got a gifted membership. I think it's a really fun way to, I love giving gifts on other channels. It's super nice. People have fun with it. It also gets you out of having to come up with something to say, right? You know, I'm not always great with words. So super generous here of Tay Biz. Tay Biz, if you guys were trying to follow the Koberger case and now that's done, make sure you give Mickey Steins a look. That case has all the crazy, right? You've got weird, you've got this town with like sheriffs and uh, individuals who had convictions but are out on some type of either house arrest or they've got ankle monitors for probation, whatever the terms are. They're getting together for like strip poker parties in people's garages, and then the sheriff walks in and shoots a judge in chambers, and there's just all sorts of craziness, you guys. So I feel like, you know, Tay Biz's community is totally up everyone's alley here, but that content, if you guys are looking for your court fill, he just what's your next thing? Because he just did deposition readings. So love those. He also looked through some of the like newer updates with the body cam and because there was extended body cam released of Mickey Steins. Well, surveillance and body cam. So vague and ambiguous says I didn't lift up my shirt. Yeah, just a whole hot mess. Just like I'm telling you, it's another bingo card case. So I think you guys will like that. I think anything that's a bingo card case, I think of you guys, I think you'll enjoy it. Oh wait, and there's 2. Thank you so much. It was 10 total. So big shout out to Tay Biz over here, gifting 10 subs, not 5. And then Peter Ortiz, super generous here with the ginormous super sticker. Thank you so much, Peter. Oh my goodness. And I'm a little sad if the Koberger trial isn't going to go forward, because I would have loved to see, as that trial started, with the touch DNA issues, the crime scene location information, how do the experts duke it out over that? And then is the witness testimony compelling? I would have loved to see what the chat thought about that, because I think the chat would have been split on that. And we get nuanced opinions in here, but I mean, when we watched YSL, by the end of it, we're like, either acquit them because we think they're actually innocent, or acquit them because the case was not proven beyond a reasonable doubt. So no matter the pathway that we got to, the acquittal was warranted in the YSL trial. We had different ways of getting there, right? But for the most part, we were really unified there. And I would love... Peter Ortiz is suggesting the preppy student murder case. I only saw like the first day of witnesses. That's not winding down? That's not winding down already? So, yeah, but big thank you again, Peter. I think Koberger would have been an interesting one. Lots of good experts, high profile case with contention, right? I think we would have had to look at other opinions here a little bit more, which is, we did not have that for YSL, by the way the state was dealing with things. And we're still seeing relics of how the state dealt with things. So let's see, argument 7 here. The court correctly vacated the 15-year sentence originally entered on count 30, but failed to rule on and vacate the entire sentence because it was imposed pursuant to a package deal. The court ruled on April 28th, 2025, that Mr. Sledge was correct. And remember, I really think Whitaker did not read the 30-something page original motion to vacate sentence. I think she just said, oh, sentence was invalid because it's beyond the statutory maximum. So, oop, I get it. I'll just fix this real quick, and just ignored everything else. Maybe. The court's amended disposition implemented the vacator of the original sentence on count 30 and detailed the resentencing on that count. The court, however, failed to rule on the argument that the plea entered on count 1 and count 30 was a package deal. And since the sentence was void on count 30, it was void as to the entire sentence, and the entire sentence should thus be vacated. So we got a lot of subsection arguments here. So first one, sentencing courts generally enjoy broad discretion in resentencing partially void sentences. The Georgia Supreme Court acknowledges that its handling of sentences that could be characterized as partially void may appear to be inconsistent. In some cases, where only a portion of a sentence, such as a parole condition, was found to be unlawful, the court vacated only that specific condition. In other substantially similar cases, the Supreme Court has vacated an entire sentence and remanded for resentencing. Far from inconsistent, pertinent precedent illuminates twin maxims. 1, trial courts are generally afforded broad discretion in resentencing. And 2, trial courts are not required to adopt a single, exclusive method for exercising that discretion. Accordingly, sentencing courts have vacated the entirety of a partly void sentence in a variety of contexts. So, got a bunch of cases here. Parrott, Kaiser v. State, Jackson v. State. In Parrott, the Supreme Court specifically, quote, expressed no opinion as to whether the trial court could also resentence on other counts, for which the sentences are not void, to preserve an overall sentencing scheme. Notably, the Supreme Court took the time to explicitly clarify that 2 prior cases, Ellison v. State and Humphrey v. State, in which the court ordered only the void portion of a sentence stricken, merely emphasized which part of a sentence on a particular count the trial court was, quote, was bolded, this is emphasized, required to vacate, as opposed to limiting the trial court's resentencing discretion on demand. In Clue, the trial court determined that Clue, the defendant, what a cool last name, had received ineffective assistance of counsel during plea agreement negotiations, but only as to 4 of the 6 convicted counts. What is it? See, this is the thing. We read an argument just above this section about, it's a critical stage, resentencing, because somebody's rights could be deprived. Somebody should have the opportunity to speak up and object. And, here, a separate critical stage, plea agreement negotiations, we're getting ineffective assistance of counsel. But when you deny a hearing at all, how do we even get there? So I'm just griping about Judge Whitaker here. In Clue, the appeals court agreed that Clue received ineffective assistance of counsel as to 4 of the 6 counts for which he was convicted. Clue subsequently filed a timely motion to withdraw his guilty plea, which was granted as to the same 4 counts and denied as to the remaining 2. This footnote says, while Clue differs from the instant case with respect to procedural posture, it has repeatedly been cited in cases concerning partly void sentences, such as Hall v. State, Kaiser I, and Halford v. State. The Court of Appeals held that the denial constituted an abuse of discretion because 1, the ineffective assistance as to the 4 counts undermined the voluntariness of Clue's plea to the remaining 2 counts, and 2, the defendant's negotiated plea agreement was a package deal, the terms of which should not be treated in isolation from one another, but rather as a cohesive whole. Now, remember when the 1AS, the first plea agreement, the one that ends up being rejected but is still relied upon during the trial as 1AS, Exhibit 1AS, the plea agreement that we're not going to tell Whitaker was rejected. The term that Mounk Tounk expected was sentencing would be withheld on count 30. All right, cool, that works for me. Let's do it. It seems like those are intimately tied together. So, in Kaiser, a physician, entered into a negotiated plea agreement. Pursuant to a negotiated plea agreement, Kaiser pled guilty to more than 60 counts, holy moly, and received a 30-year sentence. This is like gold for Fulton County. What county was this? At the plea hearing, the sentencing court sua sponte, so on their own, altered a negotiated special condition of probation, which had the effect of rendering the sentence indeterminate and therefore void. Treating the negotiated plea agreement as a package deal, the Court of Appeals vacated the entire sentence and remanded for resentencing. In so holding, the court observed that in many circumstances, it is appropriate to view the final negotiated plea agreement as a package deal, the terms of which should not be treated in isolation from one another, but rather as a cohesive whole. And let's see, this was Kaiser II. Are these different Kaisers or are these just different cases with Kaiser? Single void special condition appropriately stricken, where plea agreement left all conditions of probation in the discretion of the sentencing court. Well, where's the, here we go. Here we go. The adopted plea agreement was based on a shared misunderstanding that count 30 charged OCGA 133. 133. So we're going to go into the 131 versus 133, possession of a firearm versus possession of a firearm by convicted felon. And B, I think, is you have on that additional criteria of a recidivist or first-time offender notice. They'll probably spell it out. Let's just keep reading. Sentences imposed pursuant to 133 must. What does must mean, chat? There's no discretion here. Must be for a term of 15 years and must be run consecutively to all other sentences. 133B. Mr. Sledge was led to believe that count 30 charged 133. Thus, he sensibly and successfully negotiated for concessions with respect to count 30 as if it charged 133. He secured a promise that count 30 could be null prost, that the sentence could be nolle prosequi, that the sentence could be suspended, sentencing withheld, and that the sentence could be served on probation. From Mr. Sledge's perspective, those are the most critical points of the plea negotiations. That count 30 in fact charges 131 renders the concessions that he negotiated pointless.
Your point is pointless.
Had to run that one back. that was a day. Anytime love is wearing pink, it's always a day. Section 131, what's the difference here? So Mounk Tounk thinks all of these conditions 133. If it was 131, what's the difference? I mean, it was 131, but if he knew it was 131, what would the difference have been to his understanding? 131 carries a maximum sentence of either 5 or 10 years, depending on whether the defendant has previously been convicted of violating OCGA 131 and can be run concurrent with other sentences. So you can serve it at the same time, and it's maximum 10, maybe as little as 5. That would change the course of my negotiations, holy moly, on either side of the equation. Thus, had Mr. Sledge known the true charges and the corresponding sentences, he would have approached negotiations entirely differently. Accordingly, like in Clue, where the ineffective assistance undermined the voluntariness of Clue's guilty plea, here, the flaws in the re-indictment undermine the voluntariness of Mr. Sledge's guilty pleas on both counts 1 and 30. Accordingly, the court should treat the sentence as a package deal, the terms of which should not be treated in isolation from one another, but rather as a cohesive whole. Thus, the court should find Mr. Sledge's entire sentence void and vacate it. Oh, what a coincidence. What a coincidence. Oh my goodness. The other thing too, when we get to watching the plea hearing, we'll get Jim on for some commentary. We're going to hear Love emphasize maximum. The state will seek the maximum. And that can kind of give you the tell on how aggressively the state pursued sentencing and whatever they were representing in these back and forth multi-day email chains between Love and Wright and the meeting at whatever coffee shop they met at, where Sledge was like, you kept changing things. There were different versions. I don't know which version. Which version are you talking about? It still seems like the theme conveyed by Love is max. So again, my opinion, I would not put it past Miss Love to be misleading him that he was facing this max, this much stricter sentence. That's my gripe. Next section. The conditions of probation are applicable to both counts 1 and 30, confirming that Mr. Sledge's adopted plea agreement was a package deal. So, The conditions were set knowing that they were both there. There is no doubt that the adopted plea agreement was a package deal. And remember, this is after Glanville's, I need to learn his last name. His assistant was like, hey, there's a problem here. And then they all confer and they figure out how to restructure it so it works. The adopted plea agreement is that agreement. As reflected in the original disposition, the adopted plea agreement provided that Mr. Sledge, upon meeting certain special conditions of sentence, would be permitted to withdraw his plea to count 30 and have that count dismissed. Do you think this is a major criteria? You think this is an important criteria? If I'm going to accept a plea on 2 counts, and part of it, there's a contingency where count 30 can go away if I do the thing for count 1. Do you think those are intertwined a little bit there? Fatima. Fatima says Miss Love, aka Mouth Almighty, Tongue Everlasting, the worst Willy Wonka candy out there. The different suit jacket colors are the gobstopper layers day by day. Oh, I love this, Fatima. Good to see you, by the way. Hope you're doing well. Let's see. Thus, the original disposition specifically contemplated the conditions applying to count 1 alone or to both counts 1 and 30. Such conditions would govern the sentence on count 1. Were Mr. Sledge to serve the count 30 sentence, he would do so under the very same conditions. The sentences on counts 1 and 30, though consecutive, are structurally indivisible. Sentencing on both counts was done in tandem and cannot be separated. The state treated the sentences as a package deal. Tandem is making me think of Hilton's bike example in her closing arguments. The state treated the sentences as a package deal when it was in the state's interest to do so. Oh, this is spicy. Jim, Tiffany, I love this. Hold on, yeah. The state treated the sentences as a package deal when it was in the state's interest to do so. 100,000,000%. Mr. Sledge has consistently accepted the state's characterization, and the state should be held to that position. Yeah, so don't let them switch it now. Accordingly, the court should vacate both sentences. There you go. The chat is fanning the flames. Oh my goodness. Oh wait, Sweet Lady Sugar says his first name is Wesley, the court admin. And you guys remember the guy before Whitaker took over, the clerk that was at the computer, not Miss Weaver. Oh, yeah. I think when we do the replay, everybody will recognize Mr. Wesley. Also, thank you, Steph. Steph just dropped in the chat, help support Happily Angry Lawyer. That is Jim, who helped write this incredible motion and has been advocating, checking in with Mounk Tounk and his family. Help support him, the CashApp and Zelle. So you got 2 options there. Helping Jim out. Remember, he quit his job to do this. Like, it's just incredible. And this isn't the only situation like this that Jim is just I don't know exactly what drives it, but you know how I say I get mad and I start up a chat and I just get mad and we got to go live and we got to talk about it. Whatever you would call that thing, I think is the same thing that gets Jim behind a bunch of documents, underlining errors with his red pen. And it's incredible advocacy work that I think involves a skill set that others don't have and or don't employ. And they're certainly not willing to do it pro bono out of the just sheer goodness of the heart and raging fury about the way some prosecutors maneuver. Just an incredible, incredible thing. So Steph just reshared that, you guys. Cash App and Zelle. Go straight to Jim. Help him buy more red pens and legal pads. Maybe, Jim, you've got to make an Amazon wish list. We could send you legal pads. I would love that. I would love that. So let's see. What was the next? So we got argument 8. The 5-year term of revocation is void. because it is not predicated upon the court's finding that a special condition of probation had been violated. And if you're listening, this is a major shift to a new argument. Applicable law, probation revocation, and special conditions of probation. Earlier, I emphasized when I said special conditions of sentence. We got to read this slowly. We got to pay attention to all the words. Let's see where this takes us. We have from Legary v. State, probation revocation is governed by OCGA 42-8-34.1. Section 34.1 provides that a court, after finding the violation of a general condition of probation, may revoke the balance of probation or not more than 2 years in confinement, whichever is less. So if the balance remaining is only like 6 months, that's their upper cap. In contrast, a court finding that a probationer has violated a special condition, not general, but now a special condition of probation, may require the defendant to serve the balance or a portion of the balance of the original sentence in confinement. Let's see. Recognizing the significant consequences to a defendant for violating a special condition of probation, the General Assembly amended OCGA 42-8-34.1. And, if there's amendments, if we're amending something to make it more specific, that's a sign. Don't play with it. Play within the lines. Color within the lines. So they amend this and thus required trial courts to warn defendants of those consequences in a specific manner, in writing and place in the sentence, so as to ensure that a defendant would be notified of those consequences. Specifically, OCGA 34-1, subsection A, provides that, quote, the term special condition of probation or suspension of the sentence means a condition of a probated or suspended sentence which, 1, is expressly, it's not implied, it's not just read between the lines, it's expressly imposed as part of the sentence in addition to general conditions of probation and court-ordered fines and fees. And the distinction between general and special conditions is important too, because there is no default, oh, you forgot to fill it out, we will just default to general conditions, no big deal. They're distinct for a reason. It's codified. These are distinct things, and one is not interchangeable with the other. And 2, is identified in writing in the sentence as a condition, the violation of which authorizes the court to revoke the probation or suspension and require the defendant to serve up to the balance of the sentence in confinement. The substantive or essential requirements of 34.1a are that the trial court warn of the consequences of violating a special condition, that the warning be in writing, and that the warning be in the court's sentence. A trial court's oral warning to a defendant as to the inclusion of special inclusions of probation in such defendant's sentence are not relevant to the requirements of OCGA 34.1a. So we've got Shepard v. State, Jowers v. Washington, and from Bergen v. State, we have an oral advisement does not amount to substantial compliance with the statute that requires something to be identified in writing in the sentence. Now, if you ask me, I didn't really see anything written, special conditions written. But I also don't remember Whitaker giving an explicit reason what was violated and what the issue was. Remember, she decided on her own. She felt like it was akin to perjury. That's what I remember. In substance, due process demands that a court cannot revoke more than 2 years of a defendant's probated sentence without first finding that the state, 1, alleged the violation of a specific and valid special condition of probation. 2, detailed how the probationer's conduct violated that specific condition. So, state's burden here, this would be before Whitaker, in Adam Abate's petition. He needs to make the allegation, this is the specific violation of this specific condition of probation, special condition. And then we have to say, we can't just say he violated that special condition of probation. We have to demonstrate, we have to argue this is the behavior, this is the action that the probationer took that constitutes a violation of that specific condition. And then 3, prove that such a violation as alleged to the preponderance standard. Well, what problems did we have thanks to Adam Abate? We get some case law first. The trial court was not authorized to revoke the balance of Singleton's probation. Here from Bergen v. State, vacating 3-year revocation predicated upon violation of general condition. So again, an issue. You can't just default to relying on a general condition. And we know Page revoked 5 years. So Page can't just say now, oh, whatever. Well, it was a general violation. Well, that doesn't work because she revoked 5 years, and by statute, it's either the remaining balance or 2 years, whichever is less. You can't revoke more than 2 years if it's a violation of a general condition. So this is great writing here because the case law is obviously helpful. The case law favors what's being argued here. But to lay it all out in this way, it's like any way you might try to circumvent and find an excuse to not have to address this issue and concede that what they're arguing here is a huge issue and thus their request should be granted. They loop in the next piece of case law that's like, well, you can't move to that corner either because there's rules against that. That would take you outside the maximum for a general condition. It's wonderful writing. It's wonderful writing. For us lay people over here trying to figure it all out. Revocation of more than 2 years of probationer's probation was prohibited. And the sentencing court erred by ruling that probationer had violated a special condition of probation, and it was authorized to revoke no more than 2 years of his probation. Trial courts must strictly construe 34(1) when evaluating the legality and enforceability of a purported special condition of probation. This is Gardner v. State, finding that conditions serving as basis of revocation did not satisfy the requirements to create and impose a valid special condition of probation. Bolding, even though the Court of Appeals agreed that the condition was in all likelihood intended to be a special condition of probation. So you see that layup, chat? Somebody explain this in NBA terms. This is like the fourth quarter, right? You got to make all your strategic plays and, you know, turn the last 40 seconds into like 10 different turnovers back and forth. And you tee up all this different case law and you get to this point where, all right, so, and maybe we should just go and look. Where was this? We're on page 22. This stupid error. And this one might be incompetence, but okay. So, right, this is, okay. So going back to the 2022 disposition. So after that December plea deal, this was the final disposition in December 2022. We heard Jim talk a lot about this, but under special conditions of probation, they just jump to 2 negotiated sentence. We don't actually have any special conditions of probation here. And guess what? If you want to say, oops, it was just a mistake, you guys know what we meant. Well, no, there's case law. Jim and Tiffany are pointing out case law from the Georgia Appeals Court. That's us. That's not our neighbor. It's binding precedent that the condition, if you want to just say something's magically in there, that's not enough. Even if you want to argue that it was in all likelihood intended to be written out that way. So it's just wonderfully, wonderfully written. Oh, that's a good idea, factual lie. I could just put 22 in this box. Oh my gosh, factual lie is so good at everything. What a gem. Factual lie is a gem. There are times that I'll be like panicking. I'll be trying to grab a link and I pop back over. Factual lies already got it taken care of. So it's super appreciated. Let's see. We were here then, I think. Of course. Quote. Of course. We can get a little bit of simmer here, the shorter flames. Of course, where no rules or regulations are prescribed in the probated sentence, and no violation of a prescribed rule or regulation is alleged, The court is without authority to order the defendant incarcerated upon the theory that he has violated the terms and conditions of a probation sentence. So, remember, Adam Abate's motion to revoke, it's missing everything. So, oh, and here we go. Jim's going to lay it out. Tiff and Jim are going to lay it out. Mr. Sledge's sentence did not include any special conditions of probation, as we just looked at. Here, a plain reading of the original disposition from December 2022, which was in effect at the same time of the revocation hearing. We got a footnote. This motion does not address the significant substantive changes to the conditions implemented in the amended disposition. Oh. This is very, but wait, there's more. Let's see. Quickly reveals that no special conditions of probation were imposed. At the bottom of page 2 of the original disposition is a section titled Special Conditions of Probation. Notably, the section specifically and repeatedly uses the defined term special conditions of probation, consistent with the requirements applicable to the imposition of special conditions of probation. The section reads as follows. The defendant is advised that violation of any special condition of probation may subject the defendant to a revocation of probation, and the court may require the defendant to serve up to the balance of the sentence in confinement. The defendant shall comply with all special conditions of probation as follows. While this constitutes an adequate written warning for the purpose of establishing a special condition of probation, there are no special conditions of probation following the as follows. To the contrary, there is another section entirely titled 2, Negotiated Sentence, which reads as follows, with emphasis added. 2, Negotiated Sentence. Count 30. This is kind of important. Until. The first word here is until. Count 30, until the completion of the initial trial of this case. After the initial trial of this case, provided you have complied with the special conditions outlined in sections B, C, D, F, and I of Section 3, Special Conditions of Sentence of this plea agreement, the state agrees that defendant shall be allowed, got a footnote, to withdraw his guilty plea on count 30, and the state shall agree to null pros count 30. Now, the reason I said this word, I mean, to me, this is kind of incomplete. Until the completion of the initial trial of this case. What is until? Count 30 until. Hint, this used to say sentencing withheld until the completion of the initial trial of this case. That's what it initially said before they had to change up this plea agreement. Now let's get to this footnote. It bears mentioning that due to the use of the passive voice, the entity responsible for allowing Mr. Sledge to withdraw his guilty plea is not identified, reducing it to illusory consideration. So, where's the rest of the owl? How do I actually do this thing if I wanted to do this thing? It's not specified. Among other things, the negotiated sentence section establishes that Section 3, Special Conditions of Sentence, contains, as one might expect, special conditions of sentence. Oh my goodness, guys. I'm reading this, like everything's in my voice, you know, I'm sure that can impact how it's perceived. Like I'm obviously putting my own tone and flair to it. But even if I was like an AI reader, I think because of this emphasis, like an AI voice would still emphasize this. Yeah, as one might see, Special Conditions of Sentence contains special conditions of sentence, not probation. The items contained in Section 3 do not even purport to be special conditions of probation, which, at the risk of stating the obvious, should be addressed in the section titled Special Conditions of Probation. Oh my goodness. Satisfying the enumerated special conditions of sentence would entitle Mr. Sledge to withdraw his guilty plea. Failing to satisfy the special conditions of sentence would result in the loss of that entitlement, but apparently nothing more. There is no indication within the four corners of the original disposition that the violation of a special condition of sentence would constitute a violation of the terms of probation, let alone a violation of a special condition of probation. Finally, should any doubt remain, the items contained in Section 3, the special conditions of sentence, do not satisfy 42-8-341A2, which conditions the validity of special conditions of probation on the corresponding written sentence, providing a written warning, indicating that the violation of such special conditions of probation could result in the revocation of the balance of the probated sentence. Here, the applicable written warning contained in the special conditions of probation section is limited to special conditions of probation. There is no corresponding written warning for violations of special conditions of sentence. And remember, the way this is structured, the way this is written, we laid out all the case law first. So it says, you can't do this, you can't do that. You can't just say, well, you meant to say that. And then we say, well, here's what's happening here. It's exactly those problems. So as the reader, as the judge, what's left for you to conclude? There's a problem here. There is a problem here. Here, as was the case in Gardner, the sentencing court, in all likelihood, intended to impose the special conditions of sentence as special conditions of probation. But, like in Gardner, the sentencing court failed to follow the two requirements in order for special conditions of probation to exist. Accordingly, this court was without authority to sentence Mr. Sledge to a 5-year revocation. So this is the stinger to Paige. This is the stinger to Paige. And I hope she just owns up to it. Consequently, Mr. Sledge's revocation sentence is void. The state's this is another section of argument here. The state's revocation petition did not allege the violation of a special condition of probation. This was Adam Abate's motion. The state's revocation petition insinuates, but does not actually allege, that Mr. Sledge violated a special condition of probation set forth in the original disposition. Section 3 of the revocation petition, titled, this is the header title, Defendant Violated Special Conditions of His Probation, sets forth the state's argument. All mentions of special conditions contained in Section 3 are briefly addressed below, with emphasis added. So first segment, the first sentence of Section 3 reads, the defendant has violated all the special conditions of his sentence outlined above. The conditions outlined above are all special conditions of sentence. See original disposition. As established in the preceding section, special conditions of sentence are distinct from special conditions of probation. Adam Abate should know better. One of those questions, is it incompetence or does he know what he's doing? There's a footnote here that says the language of the conditions outlined above is excerpted from the first plea agreement, but attributed to the sentencing court's original disposition. So it's taken from the first plea agreement that was rejected. But we heard earlier raised in this motion, and maybe somebody will dispute this. I can't wait to see if Love comes running. No, I have the written copy of the other thing. It's kind of a catch-22 for Love. You know there's a written copy of the amended plea agreement. Nobody else has that. And then during trial, you're admitting 1AS, which is the first plea agreement. So come running with that now. Please come running and waving this thing that nobody's seen. Especially when Adam Abate is relying on the first plea agreement when he petitioned in October 2024 to revoke Mounk Tounk's probation. He's taking something from something that was rejected and attributing it to a disposition. I'm not a lawyer, but there's a big difference between a plea agreement and a final disposition because one is accepted by the judge and one may or may not be. And in this case, we know it wasn't. So there you go. There you go. Side-eyeing here. Side-eyeing Abate. Let's see. Next, the revocation petition asserts that the defendant directly contradicted the special conditions of his plea agreement. We already know where this is going to go. By disavowing the factual acknowledgments. And then we know that that's what Love was pissed off about, right? You're not testifying to what I want you to agree to when I have you on the stand. Again, special conditions of Mr. Sledge's plea agreement are not special conditions of probation. More fundamentally, the parentheses void, the void first plea agreement was not Mr. Sledge's written sentence. The original disposition was. This is like, we will know if Whitaker actually reads these arguments or not, because this is a huge issue. Abate at the revocation hearing where Love showed up in her leather jacket but didn't participate. Isn't that funny? Isn't that interesting? And then Love introducing 1AS, the first plea agreement, which was rejected, and Love delivered that. She was there. She would have known it was rejected. The things that she's introducing in court when Whitaker's presiding over the case at that point in time are now leading to a situation where Whitaker didn't even fact check, and Derek Wright certainly didn't push back against the petition for revocation. And that's a separate argument, right? If this continues to move forward, I mean, I'm sure that'll come into play. But here, this is setting up for Whitaker to look like she just accepted the prosecution at face value for anything that they represented to the court. And she knows she has to clean up their messes. She knows she's cleaned up their messes before. Oops. So I think, hold on, I skipped a sentence here. So more fundamentally, the void first plea agreement was not Mr. Sledge's written sentence. The original disposition was. The revocation petition's reference to the void first plea agreement are misguided. Well, this is a very nice way to put it. This is a very unassuming way to put it. A very generous characterization. I'm like, no, they knew what they were doing. They knew it would misguide somebody else. But I think they did that intentionally. The revocation petition continued. Most importantly, the defendant acknowledged that he understood that any violation of the special conditions of this plea agreement, again, the first plea agreement, could lead to the revocation of his probation, with the district attorney recommending the maximum sentence allowed by law in the Georgia Department of Corrections. So we got a footnote here. As discussed in the prior motion and the court's vacatur order, the quote maximum sentence actually exceeded the statutory maximum sentence by at least a decade. Thus, the state threatened Mr. Sledge with an illegal sentence, and nearly 2 years later, turned around and used Mr. Sledge's acknowledgement of that threatened illegal sentence in support of its contention that Mr. Sledge is amoral. Oof. Now, this is a bold and very rude, in my opinion, unethical, immoral thing to do. But legally, there's an issue here because you get him to supposedly, they keep relying on this factual acknowledgments thing. Well, he only gave you those factual acknowledgments under certain conditions where he thought he was facing a much harsher sentence that he shouldn't have been facing. And he ultimately was sentenced to something that's not allowable by law. So, and I know they always say you're doing this voluntarily, right? But I think we can all agree that semantically, plea deals in some manner, shape, or form. There is pressure there. It feels coercive. But ultimately, yes, you do end up volunteering in a way to say, whatever, I'd rather just take this route than that route. So I'm going to acknowledge these things just because of this is the path I'm choosing to take. So I'm going to choose to acknowledge these things. Well, if that agreement is void, factual acknowledgments might have looked differently if things played out differently from the start. So, yeah. Tavis says, oh, the misguide is real. Yeah, it sure is. And Keisha, kind words here for Happily Angry Lawyer, says, thank you and Tiffany for taking on this challenge. Every motion written is perfectly executed. I'm 100% agree. I am a Jim and Tiffany fan, a stan maybe. And I'm just disappointed that it seems like Whitaker didn't read their first motion. She ignored the entire package deal argument. But I guess that just opened the door for them to bring more issues forward. And if that didn't happen, if Whitaker paid attention to that back in April, then this call out of the additional, what I'm assuming, what I'm characterizing as funny business by the DA's office, we wouldn't get to see these call outs here. So the reason it sucks is because Mounk Tounk's still in custody, right? But with that aside, I think these call outs, if people pay more attention, this certainly cannot be the only time some mess like this is happening. So I'm glad that there's a light being shined on it, although it's really unfortunate that somebody's in custody while somebody just plays games. But super, super nice words here from Keisha. Let's see. I went down a little bit. I was scrolling while I was talking. Okay. Let's see. Yeah. So again, the state does not identify any special condition of probation and does not reference the original disposition. The penultimate sentence and the last to mention special conditions reads, "It is evident that the defendant knowingly and willfully violated the special conditions of his negotiated plea agreement. Consistent with the foregoing, no special condition of probation is identified, and the original disposition is ignored." And there's no way Abate doesn't know better. In sum, the revocation petition alleged that Mr. Sledge violated 1. Special conditions of his sentence, 2. Special conditions of his plea agreement, 3. Special conditions of his plea agreement, and 4. Special conditions of his negotiated plea agreement. Not once is the violation of special conditions of probation alleged. More importantly, the revocation petition never alleged the violation of any specific special condition of probation. And this is critical because the sentencing, there's case law, it has to be explicit. It has to, if you're going to sentence above the 2-year max, it can't be a general condition. It has to be a specific condition. And meaning for it to be one or the other isn't enough. It has to actually be written. So these are huge problems. And again, a judge can ignore them and issue a bad decision if they want, but it seems like an invitation for someone, an advocate that's actually caring, to take it up further through the appeals court. I don't think Paige wants that. D. The court's revocation order did not find any violations of a special condition of probation. So now we're moving on from what the state didn't do in their petition. We're now moving on to Whitaker. So the court's October 18th, 2024 revocation order provided the court's findings. The preponderance of evidence presented compels this court to find that the defendant has violated the special conditions of probation as alleged in the petition for revocation. No violations of any specific special conditions of probation were found. So she didn't put one on the record either. Pursuant to OCGA 42-8-341C, and Mr. Sledge's 5-year revocation is contrary to applicable law. As discussed in section 1 above, a sentence is void if the court imposes punishment that the law does not allow. Such is the case here. Mr. Sledge's 5-year revocation is contrary to law, void, and must be vacated. So conclusion, wherefore the double jeopardy clause requires the vacator of the 15-year sentence imposed on count 1 as amended by the amended disposition. The court's vacator order and amended disposition extended the term of count 1 sentence by essentially restarting the 15-year term on October 18th, 2024, rather than running it from December 28th, 2022, as in the original disposition. Separately, Mr. Sledge's sentence on count 30 was correctly found void and vacated by this court. The accepted adopted plea agreement was a package deal between Mr. Sledge and the state, and the court should not treat its terms in isolation. Given that the court vacated the sentence on count 30 and that Mr. Sledge's sentence was imposed pursuant to a package deal, this court should find the entire aggregate sentence void and vacate it. Finally, Mr. Sledge's revocation sentence is void because there were not any special conditions of probation included in Mr. Sledge's sentence or alleged to have been violated in the state's revocation petition. The court did not find any violations of any specific special conditions of probation. Because remember, all we got was, I find it to be akin to perjury. Well, then maybe someone should pursue charges for perjury. It's not really how we can just summon a special conditions and say it was a violation of one that he agreed to 2 years ago. We can't just summon that out of thin air. The court did not find any violations. Accordingly, the 5-year revocation sentence is not authorized by law is void and must be vacated. Mr. Sledge reserves his right to withdraw his plea and exercise his constitutional right to a jury trial at any time prior to sentencing. In any subsequent sentencing, it's like we have to remind the court. Mr. Sledge is entitled to be present for such resentencing, and the resultant sentence must be announced in open court. So we can't just woohoo, write down an order, resentencing, and say that Tiffany Adams was there. No, he's entitled to be present. Mr. Sledge requests a hearing on this motion. Respectfully submitted this 30th day of June, 2025. And look at the beautiful Tiffany Adams signature here. We got the digital from James Robichaud. This is such a nice signature. I love it. Super, super nice. So there we go. We've got a lot of extra things in here we can break down. I want to get Jim up here. Let me get the link here and get. Sorry, Jim. I should have messaged you the link earlier. In my head, I guess somehow thought you could just pop up on here. So I just sent the StreamYard link over on X to you, Jim. Let's see. And then Derek, thank you. Good to see you, Derek. Yeah, nothing signed in Idaho 4 yet. I mean, still, to me, it's big news that it's even on the table being considered like that. And of course, even if it's completely true, right, he could still change his mind by tomorrow. And then also it could be maybe we have the details wrong. So, and yep, thank you. Factual Lie is on it. So Sledge, 5 years were revoked, which is, again, it has to be that special conditions violation, because even if we tried to assume, which we're not supposed to do, it was only a general, the max would be 2-year revocation. So we've got Jim in the building. Let's get some W's in the chat here for Jim.
Hey, everybody. Can you hear me okay?
Yeah, you sound good.
Okay, good. Better than last time.
Yeah, that was a time last time. So any any thoughts? I mean, to me, I feel like you guys wrote that in such a gentle way that even the spice is, you could say it's not really spice, but it is spice.
Yeah, it could have been worse. It was worse originally, but
maybe one day, Jim's greatest hits. Look at all the W's in the chat. So guys, remember, I should have said it before you came up so I don't put you in this position, but CashApp and Zelle for Jim in the chat. Help support his pro bono work here that he's doing. And, just he shared the documents over on X. If you guys use X or other social platforms, make some noise about this renewed effort for Mounk Tounk. I mean, we're seeing, even if you join the stream today and have never heard about Mounk Tounk before, but you're like, wow, how is a prosecution team and the courts aren't even paying attention to the orders they're making, what they're sentencing people to. I mean, there's so many, like the Swiss cheese layers. There's so many different layers that could have been stalwarts. They could have, oh, no, that won't work like this. And the only time it seems like we got that was when Glanville's assistant was like, structurally, he can't be released today.
Yeah.
If we don't restructure this. And that was a favor to the state. I know it seems like a favor to Mounk Tounk because he could be released today, but it's really the state that wanted that leverage, and they held that leverage. And they knew that Mounk Tounk would agree to what they laid out if he could go home and see his sick mom. So really, Glanville's assistant giving Love the opportunity to go and make that work was a huge benefit to the state. My read.
Yeah,
okay.
I mean,
we got PayPal too, guys. So same email here, I think. Oh no, different email.
You don't need to donate anything, but I appreciate it.
So there we go. But sorry to cut you off.
Yeah. What was I saying? Yeah, there's a lot of stuff. I still haven't used. I've used well under half of what I could use to get him out of prison. Like, getting his entire conviction vacated will be easier, significantly easier than getting the probation revocation vacated. But yeah, there's so much to go on to use. I mean, we didn't even talk about the revocation hearing yet. That in and of itself was.
That's something
a
that's always
disaster.
peeved me, the akin to perjury. And that's why I keep saying it, because it's like seared into my brain when it happened. Like I can be forgetful. I'm not very good at pulling quotes forward, but when something really, it just makes me feel a certain way, I remember it. And that akin to perjury, I was just like, that's not how this works. And it was like
Yeah.
she was volunteering a reason to come up with a sentence on behalf of Abate, because Abate was like, I'll leave it in your discretion.
You-
And now in retrospect, and
I'm
knowing
gonna get
that
myself in trouble.
so I've got a rant. So in retrospect, now knowing Diamante Kendrick at his
Yeah.
his final hearing for his other cases, where AJC Joseph Papp reported that Abate was like, just accept the deal and you go home, just say yes. So that's a little bit of a different attitude than what we had at the revocation hearing. But in retrospect, I'm thinking Abate was doing that because he didn't want to draw attention to his basis for asking for a certain sentence. He didn't want to ask for more or less than 2 years, because it could cue a judge in to ask for, well, is it a general or is it a specific violation? And then you have to name a violation, period. So
Yeah.
I thought that was weird of Abate when it was happening, that he was just leave it in Whitaker's discretion. But now I feel like it was intentionally meant to benefit him and keep the radar off his back.
Yeah. So remember that in the revocation petition, they said that they were going to ask for the balance of the sentence to be revoked, which would be like 27 years. And then it kind of came across as if you were being charitable and saying, I'll leave it in the court's hands. But by not recommending 27 years, he was avoiding
getting called out.
Not just that, he was avoiding arguing an illegal sentence. He would have been advocating for an illegal sentence if he asked for what he said he was going to ask for. So he kind of avoided the ethical violation by saying, "Oh, I'll let the court decide." And he kind of looked like he was being the good guy.
Right, it looked like he was being generous, and that's a huge contrast to what he acted like at Diamante Kendrick's hearing. And Abate was a bit like, at that point in time, he hadn't really come in quite as much for the YSL trial. Like, any familiarity I had with him was him being the boring guy reading the PowerPoint presentation during the Fonnie Willis disqualification hearing. Like, if you guys paid attention to that, it was a boring presentation.
I just remember the PowerPoint in the YSL closing had like the ninjas on it or something. It was Atkins' PowerPoint with like, okay, I don't know. It was a long PowerPoint, but there was a slide with ninjas that Christian had said.
I'm just thinking of Atkins' hands.
I'm okay.
Oh my goodness. Yeah, so that's a whole new light for me with that plea hearing, because I thought it was weird that Love was there, but like popped in at the end, but we couldn't really tell where she was. She could have been there the whole time and taking the back seat, or she could have walked in after, oh, I didn't hear you say something that I should know better and have corrected the record on, so I'll just wait to come in later. And again, this is my speculation, you guys. I'm not impugning any opinions onto anybody else, but it just all looks extremely funny to me.
Yeah, no, looks funny to me too. There's one thing that I think was I should know. I mean, I wrote this part, so I should know. But let me see if I can find the page number. There's something about the factual acknowledgments. I think it's one of the footnotes. Page 8. If you go to page 8, this is a point.
The factual lie strategy. Yeah. Okay. Okay.
Yeah.
So notably, the defendant's factual acknowledgments are not among the provisions excerpted and included in the original disposition. So we should go to, what exhibit was that?
This should be bookmarked. You should be able to go to.
Oh, this is cool. Oh wait, but I don't know what they are. We'll just jump and do one. It's I. Look at you go.
Yeah.
This is amazing.
Wait, is it? No, it's not.
December. This is October. This is the October one.
Oh wait, no. I think I cited the wrong thing. Actually, that might have been a mistake. Let me see.
Well, you might have cited it correctly and not. Oh no, I guess the header would pull directly from it. Let's see. This is the motion to revoke probation. This is Adam's motion, you guys.
It is page.
Chief Judge Glanville imposed several special conditions on the defendant probation.
It might say special conditions of probation.
This is a mess. You should do a stream on the transcript of the hearing that was not caught by Law and Crime.
That's a good idea.
That would be amazing, you guys.
Oh, go to page. I don't know why I started talking. I'm on the wrong page.
Also, you have a question. Alethea asks, what compelled you to go this deep?
I don't know, pettiness? It's page 542. What compelled me to go this deep? I mean, at first I was just interested in the law and the Georgia law because it wasn't something I had any experiences with. This is my first criminal case. I've never done any criminal law until, I guess, October of this year. So I was just learning. It was interesting. I was kind of following this after work. And so when I started looking into this case, I was confused because I didn't understand what was going on. And I didn't understand why his sentence was the way it was.
Now, I'm going to interrupt there. Did you feel like something was so wrong with it that you just felt like it couldn't just be that you didn't understand the way criminal deals work out? Like it was just something so off about it that you're like, I gotta figure it out.
Yeah, I was like, surely it's not this simple. Surely it's not just that 15 years is more than 10 years. There has to be a better reason for why this is the way that it is. And eventually I think I asked on Twitter what I was missing, and I think it was GSU Grinding, he's a really good Georgia criminal defense lawyer. And he was like, no, you're not missing anything. And so after that, I just kind of wanted to see how far it would go. And so I just started reading, and I kind of came to expect every document to have a mistake. And so it's not like I'm checking to see whether there's a mistake in every document. It's like, I know there is one. So I'm just trying to find it. That's kind of sad, but it's the truth. And yeah, so I just kept reading and I kept finding mistakes. But that's really what it was. I was trying to figure out, it was like putting a puzzle together, except they kept adding pieces of the puzzle as it was going. And the picture kept changing, but it was like trying to solve a puzzle, I guess. That was kind of the appeal.
When you were into all of the previous cases, because guys, this wasn't addressed in this motion, but it was touched on, I think, in a footnote in your previous motion, and you talked about it on a stream, or 2 streams, I think. This plea hearing, or this revocation hearing, Whitaker calls up this probation officer. We don't really know much of who she is, and she starts rattling off a list of all these prior offenses. And then when you're doing your deep dive, you find out that there's actually an Anthony Sledge, who is not Antonio Sledge.
No.
And it's just, were you like reading it and you're just like, wait a minute, and you had to go back and say, hold on, this is not the same person.
That was the thing that took me the most time, because I just couldn't. I mean, first of all, a lot of this stuff was so long ago that they don't have everything uploaded in PDFs on Odyssey, so I couldn't get everything. So I had to piece together from different different case numbers, all of Anthony's information and all of Antonio's information.
You know, like, is Anthony like in custody somewhere? Like, did you do any research on who this Anthony person is?
There's one in California, and he's about the right age. And I was like, I hope I'm not like getting this guy in trouble, because he's right down. He could be like right down the street.
Oh.
But no, I don't think so. I think his last conviction was in like 2010, and it wasn't a serious thing.
That's cool to know.
It took a really long time. And the funny thing is like Antonio's, his actual records are so mixed up and jumbled and wrong that I couldn't tell whether mixing up Antonio and Anthony was just a normal mistake or if there actually was a person with Anthony.
Did they mix up the people, or was it just a typo? Because they've also, I mean, the Quantavious Greer is another one. We've seen a million different spellings for Quindarius Zachary. Like sometimes he has like 2 S's and other times it's Zachary with a H and not. It's not unusual for that to just be what's going on.
Yeah.
And
I don't think they ever spelled Greer's name correctly. I didn't know his name until recently.
like the correct spelling, you mean?
Yeah, it's Quintavious. There's no O in the name. It's just Quintavious.
Quintavious, not Quintavious.
Yeah. No, it's much simpler than that.
No, I'm wrong again. I'm always wrong with names. I thought that was more of a difficult one.
No, it is.
I thought I had it right.
In all of his in all of the the state's filings, if they say Quintavious, that's just not his name. I mean,
oh my god. Just imagine the nightmare of having a common name.
I didn't tell you this. There's a second Antonio Sledge too. There are actually 3 people that have been mixed up. I just haven't had an opportunity to talk about this, but there's actually an Antonio Sledge who was born in 1961. I guess he actually got mixed up with younger Antonio Sledge once too. So there have actually been 2 other people that have been confused.
What is this? This is like the Kang universe, but it's just Antonio Sledges. And one of my favorite internet memes, like Internet Archive, is the name was Christopher. I don't know the last name. Maybe it was like Christopher Smith, but it was just a Facebook group chat, and it was a bunch of Christophers, and it says has been added to this group. And the one Christopher's like, I think we all know why we're here. So this guy just invited every Christopher Smith he could find into a group chat and said, yeah, I know why we're all here. And that's kind of what it seems like. They just rattle off these names. But then they have this probation officer rattle off all this back history that, they yell out a taboo sexual assault offense that doesn't even belong to the actual Antonio Sledge. And then
that one doesn't belong to anybody.
5 years. Did none of them have it? It's not even inexcusable.
No. And that was under, if you listen to I haven't talked about this before, I don't think, but if you look at the revocation transcript, the officer, I know her name's Officer Jolly, I don't know her first name, but Officer Jolly says it's under indictment 15 SC 138994. And that's the case, the Dell Avenue case, the 2015 case. So the SA it never happened, but the case that they're saying it was under was the Adele Avenue, the alleged drive-by case. So it doesn't even make sense that it would be under that indictment. And we know that the state had very famously read the factual acknowledgments from that case into the record. So they should have recalled that there's nothing like that in there. And also, never mind, I'm not going to say that part. But there's even more to that story as to why they should have known that it was not real. And that wasn't even the only mistake in that indictment. In that case number, they said there was a 131 conviction, and that's also not true. And they
probably had a relic that he was being charged with one thing here, and then they changed the charge, and they got the memos crossed because, I mean, how often are those charges not confused in Fulton County? By design, maybe.
Well, I mean, the thing is, they've gotten it right. They've been getting it right for 2 years. Like, they got it right on December 1st, 2022. Like, in the recidivist notice, they said the offenses correctly from 15 SC 138994. So during this case, they forgot and then relearned the offenses in that case, apparently. But they've repeatedly gotten those offenses correct throughout this case. And then it comes to the revocation hearing. And
well, I was going to say famously when they did jury charges, and that was a successful motion for a directed verdict on the 133, but with the permission that they could submit it to the jury as 131. So
yeah, I mean, technically that's correct.
So I think that was like a super lucky moment for the state, because I do think those, and we saw the one conviction on gun possession. I think the gun possession was the least far-reaching of some of the other things that were included in the indictment. But again, only with the elements, right? If the issue is supposed to be during the commission, but you're not naming the other, the cash out trial, which you guys have been asking for, there's no stream any longer for that. I don't know the reason why. Day one, they showed the jury, so that could be it. Or perhaps because of the nature of the testimony, it was only ever permitted for opening statements. I don't know. But that was argued too by Carrington Matthews, that there is a possession charge, but the element requires that possession during the commission of another felony, but there's no felony alleged.
That indictment was, if it was less serious, it would be hilarious. It's so bad.
I'll say another great stream. I saw Aaron, before you did your stream on it, I saw Aaron talking about it, and Aaron's in the chat still, I think, with Millionaire Mel, with Verdict Mel. And I think she had a similar conclusion about the cash out indictment. But it's one of those things, like you said earlier, like you go into things looking for mistakes. And it's like when I see somebody, when I look at other cases and I see a 133 or 131, and I forget, I think 146 is the one Carrington Matthews. It was a different but similar type thing. It required the element during possession of something during commission of a felony. But there's another statute with another tack on to it. Now when I see those,
106. Possession of a firearm during commission of a felony is 106, and that requires it's really close to 133. You just don't have to be. It's minus the convicted felon part. So it's using a gun during a felony, just period.
Yeah, so I think the 6, that sounds right, because I remember the 6 for whatever reason. But it's like when I see those come up now in any case I'm looking at, I feel like I'm doing the target the mistake, because right now I feel like any case I've looked at with those charges, there's like a 50-50 chance that it's incorrect.
That's generous.
Yeah, right. It feels like that. And if I see multiple indictments, it's not just like, I used to look at a new indictment. We found more evidence and we're alleging new things because we found more evidence between the first indictment and now. Not we're changing the way things are written, but not really changing them. We're like changing some parts of it and leaving the others copied and pasted because we're trying to figure out how to push plea negotiations in our favor or whatever the rationale is. That's not the mechanism I used to understand re-indictments being for.
I didn't notice this until this, I think it was last week, but Eppinger's 131 counts. Do you remember count 35 had to be dismissed?
And repeated like 4 hearings. The attorney had to keep saying, "That's dismissed, Your Honor."
That was, I haven't done a video on it or anything, but that was because of the re-indictment. It wasn't originally duplicative, but then at the same time they changed Sledge's 131 counts, they changed Eppinger's, and they basically voided 35 the way they changed it. And they also changed Trontavious Stevens as well. But this is all related. And I mean, even the YFN RICO, there's an illegal sentence in that case because of 131, 133, 106. I just haven't gotten to that one yet.
Hold on, wait, what was your 542? Why did we go to this?
Oh,
look
okay.
At the header?
Nah, this is, go down actually. Go down to, So this is, I kind of allude to this, or we kind of alluded to this in the motion, but this is akin to perjury statement or conclusion or finding is based on Sledge not repeating the factual acknowledgments. So just take a step back and ask what factual acknowledgments? Where are they?
I don't know. And it's in quotes.
That's my question.
It's in quotes. So like when things are in quotes, I expect you've identified this already. You've said it's attached somewhere. You tell me where to find it. It's in quotes. And then what do I do? Where do I go? I look at am I just supposed to go look at a rejected plea agreement on my own and just decide we can use that still?
Yeah, go up to C. It says, oh no, I meant letter C.
Oh, so wait, that was like H, right? I think.
Yeah,
Wait,
it's
no, I don't remember what it was.
542 or 541.
And then C.
Yeah.
So this?
Yeah, so in accordance with testifying truthfully, you acknowledge that each and all the statements contained within the factual acknowledgement section of this agreement are true. So, I mean,
It
I think we
says
talked about this last time.
You're constrained to looking at this one. So even if and I shouldn't be allowed to just go and wander and find things on my own, it should be spelled out. But even if I gave myself that permission, the special conditions are constraining me to only rely upon what's in this specific thing. Where is it?
Yeah.
Where is it?
Yeah, so really, I mean, if you think about it, he was in trouble for violating the special conditions of probation by not testifying in accordance with the factual acknowledgements. And you don't have any of those things. It's not even like there's one mistake.
And then we get her reading the Alford plea into the record.
You know, she was on that case, right? In 2017.
So she can't just pretend she looked at the docket and pulled the wrong filing and didn't know any better. She
actually did Mounk Tounk's first plea hearing. That didn't come out during the YSL trial. She overstated the prospective sentence, and had Sledge walk away. And then the second hearing is the one that was referenced in the YSL trial. And that's when there was it was basically an Alford plea. You remember the first day of testimony where Sledge was being asked about the difference between a blind plea and a negotiated plea?
Yeah.
He was right about everything that he said. He said, I was doing a blind plea, but I knew the sentence, they had something worked out beforehand. And the questioning was kind of intended to make him sound like he didn't know what he was talking about, or that he was lying, or that he was being dumb. But if you look at the transcript, he's right. There was an agreement between Charlie Bailey, the prosecutor, and Derek Wright, the defense lawyer. So they had agreed on what the sentencing recommendation was going to be. So even though it was a blind plea, the lawyers did have something worked out, which technically that's not, I mean, I don't, that's really a fully blind plea. But I mean,
I feel like anything where this stuff is changing overnight and you don't really know, it might as well just be called blind.
Yeah. And I mean, it was used to make him look dishonest when he was being honest. And it made him look like he was dumb when he was the only one in the room who was correctly recounting the facts of what happened. And I think that's the theme of his case, is he has been correct and truthful repeatedly, and the state has been neither of those things constantly.
And nobody has done the mess to unravel it. And again, you are doing this pro bono, but the state operates on resources. The state, they're paid. They have their salaries. When they're doing work, they're not just doing it for free, or if trial goes longer, they're not just stuck with the flat rate they agreed to. They continue to earn and get paid. So to me, it's just inexcusable that they're all beyond getting the documentation right, except when it works for them. They'll go and get the documentation. They'll do their homework when they want to file a recidivist notice and make sure it's known that they're pursuing an aggravating factor. Then they suddenly rush to make sure paperwork is done early, on time.
Yeah.
Any other situation, we don't get the paperwork in.
Yeah. Oh, there's one other thing I wanted to say. Just kind of taking a step back, bigger picture. If you think about the reason that Sledge got in trouble, even from the state's version of facts, let's like say everything that they say is true and you accept their version. And like he was, actually, no, let's not go that far. So their theory, what Sledge said is that he's confused about the plea agreement. But the thing is that nobody knew what was in the plea agreement. Nobody knew the terms, not the court, not the prosecutors, and not the defense lawyers. But Mounk Tounk was the only one who was blamed for that. It's not as if he was confused about the terms of the plea agreement and everybody else understood them perfectly. Nobody knew what they were. But the only non-lawyer in the situation is the one who's being condemned for not knowing the terms of the plea agreement.
Yeah,
That's
it's like
ridiculous.
if the agreement is outside the bounds of what's legally permissible, then it's not a voluntary acceptance of something. You can't accept an illegal or null and void contract. So just by definition, if he's not understanding something, but this context is there, it's not on him.
Yeah, and I mean, yeah, no, you said it, and I mean for the same reason. That's why his.
But they
I had to take this card out, but I mean his plea agreement, his guilty plea is not effective. I mean,
yeah, that's what I'm saying. I really think we could find out, and I would love every single. You guys told me over on X when I asked that the reporter chasing down Fonnie Willis, his name is Chase Houle or Chase Hule. So this guy, I would love to see him like start the counter back up. Like, did the YSL trial really end? Do we really have a disposition? No. Or is it still going? And again, like these stories make me wonder about all of the other plea deals, because we know this wasn't the only plea deal here. Is the same issue at play somewhere else?
Yes, objectively, yes. I know for a fact that it is.
And this is what I mean. So you're doing this for free, but we have a whole department who's paid on salary, and maybe they don't love their job, right? Maybe they don't love going to work every day. Maybe they feel like they should get paid more. But at the same time,
I don't love them going to work either.
Yeah, he says, get out. Just don't even go to work. It'd be easier that way. But it's like so much of this could be avoided with just a little due diligence. If someone's doing something intentionally, why isn't somebody else reviewing these documents and also catching it? Is it just too much trust?
I think it's different things. I mean, sometimes it's a mistake, sometimes it's on purpose. I don't know. It's everything.
It's just crazy.
Yeah, it is. Oh man.
And I think where do I want to play that one thing while you're up here. What day was it? Let me make sure. I'm going to start it in another window just to make sure I have the right stream. Let's see. Yeah, I don't know what it is. I think because I watched all these clips yesterday.
Which one are you looking for?
The one with the video and the timestamps.
It's 125.
Day 125?
Wait, yeah. Or is it?
Or is it day 124? Oh, it's day 124. Okay, I have it. Guys, we are going to watch Adrian Love. Now, this is the December 2022 plea hearing on the screen, but this is being played during the YSL trial. She ran it back for the court. So we're going to go and listen to what Love does with this fun clip. Now, mind you, this sentencing withheld. Can you explain why the sentencing withheld is important language?
Yeah. Actually, do you want to go back to the 541 or 2, whatever it was? Yeah, go back up. So count 30, it originally said, or go down a little bit more. Just to
it's not letting me zoom in.
Okay. Yeah, there you go. So that originally said, you said this before, but
this giant space.
Yeah, it originally said sentencing withheld until the completion of the initial trial of this case. So if you hear that sentence, there's no way to say this without sounding condescending. It means that the sentencing is going to be withheld until after the trial. So they're about to play a video during the trial that would otherwise say sentencing withheld until completion of the trial. But the lawyer should know that he was already sentenced on count 30. So if you hear sentencing withheld and you look at this document that we're looking at now, if you look at the sentencing sheet, you'll know that there's something off. And you'll know that the plea agreement, there's something wrong with the plea agreement. And you'll just start pulling on the thread and it'll take you to the truth.
It'll take you down the void.
Just the words, just that one sentence is really critical.
So here we go. I think I have it queued up to the right area. It's going to be about like, I think 3 minutes to get through it because we got to watch them finagle with the tech they can't figure out.
Yes, ma'am.
Have you had enough time to speak with your attorney
No, say no.
about all of the facts and circumstances known to you?
No.
Charges in this indictment.
Yes, ma'am.
Any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
You need more time.
Are you satisfied with his services?
Yes, ma'am.
Do you waive a formal reading of the indictment?
Yes, ma'am.
Do you waive any and all defects in the indictment, including any with respect to your name?
Yes, ma'am.
Have
Wait, you should
been
pause real quick,
arrested
actually.
on these
Okay,
charges?
okay.
That is actually, I don't think I've had to discuss this, but you can't waive, I think, 2 kinds of defects. And one is that there's no crime alleged, or that the crime that's charged in the indictment isn't alleged. So that's why, even though he waived defects in the indictment, that's why we're still able to attack the indictment.
Oh, cool. Do you know what the other thing is offhand? You're learning so much about the criminal realm. This is awesome.
I've known this stuff for like 6 months, so I'm not an expert either. Let me see that one. What is the other one?
That'll be the mystery for us to figure out. We'll have to bug the criminal defense attorneys that we know.
Yeah.
Be like, hold on, we're trying to learn. We're trying to learn. Also, you paused it at the right time. STS is here. STS, thank you for showing up. I think when you go back, you're gonna hear Alethea in the chat had asked what made Jim do a deep dive, and how Jim got to this point where he started to feel like, I'm gonna open these documents and something's gonna be wrong in it. I just know. And Jim, you have an attorney background as a civil attorney, but it's just sometimes just the frame of mind, thinking about things, just having an intelligent way of digesting and bringing in information. And if you guys remember STS, his name used to be Stephen Satchel on here. He noticed the same issues. He's like, this cannot be a valid plea agreement. There's flaws here. There's just something. And he came up with a ton of explanations that made sense. And again, he's a layperson. He's not an attorney. But there's these issues with these things. So it's great to have STS in the chat here. Big thank you here, donating the 5 gifted memberships here, growing the gang and making the chat turn green. Be careful, because this indictment might not be done. It might come back to life. So big thank you. Lots of love here for STS.
That's one thing I would say. Oh, sorry.
No, go ahead.
Like, not knowing, if you've seen something 1,000 times, you're going to expect it to look a certain way. But coming to this case, I had no idea what any of this stuff is supposed to look like. So I think that was kind of an advantage in this case, because I was reading everything for the first time. So there wasn't, my brain couldn't go into autopilot.
Fatigue blindness.
Yeah,
that's a good point. Yeah, and it's just like, again, I think at the beginning of the stream, we mentioned, and again, the Koberger trial is up in the air. It seems like he might be considering a plea, but we won't know until we know. Maybe we could dissect that plea if it comes to fruition and see, did they go through the motions the right way? Yeah, right. I don't know if there is a plea, I don't know if there will be the flaws that we're finding here. But that lack of contention, I think a whole chat of us that had to learn as we went. We had to learn day by day what was going on. New case law was being introduced because some issue happened the day before. But there was just this gut feeling, this shared in unison gut feeling that something isn't right. And that's just crazy to see such unison on any internet topic. And that's such an L for the state. Are you good to resume?
Yeah, sorry. I'll stop yelling stuff. I'll stop being that guy.
That's okay.
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Do you, Mr. Wright, know of any outstanding warrants that are related to these charges?
I do not.
Mr. Sledge, has your attorney advised you of the minimum and maximum sentence for each charge that you are pleading guilty to
Yes,
today?
ma'am. Yes, ma'am.
Zoomed in on love. My camera
Do
person.
you understand that this is a negotiated plea of guilty?
Yes, ma'am.
Which means that the state will recommend to the court the following sentence.
Yes, ma'am.
As to count 1, 15 years to serve on probation, subject to the special conditions contained in the plea agreement that I have in my hand that I will show you in just a moment. And on count 30, although you are pleading guilty, sentencing will be withheld until the completion of the initial trial of this case. After the initial trial of this case, provided defendant you have complied with the special conditions outlined in sections B, C, D, F, and I of section 3, special conditions of sentence of this plea agreement, the state agrees that the defendant shall be allowed to withdraw his guilty plea on count 30, and the state shall agree to null pros count 30. Do you understand that the court does not have to accept that recommendation? And we will read into the record the terms of the plea agreement in a moment. Do you understand?
We will read into the record the terms of the plea agreement.
Now,
She did eventually.
well, I was gonna say, and remember, this is all before they end up, oh, there's gonna be a problem with this. So this is not the final plea agreement.
That.
Yes, ma'am.
Do you understand that the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other if the court does not accept that negotiated plea?
Yes, ma'am.
I'm showing you what has been marked as State's Exhibit 1AS. Do you
Yes.
recognize the document in State's Exhibit 1AS?
Yes,
Say it,
ma'am.
Jim.
And is that your signature
Okay.
on page 7?
It's dated December 27th. It's the wrong one. Like, even aside from the first thing, it's wrong for that reason. Okay, I'm sorry. I'll stop.
Wrong one. And then they continue to use the wrong one in trial. And this is why, that's why they're playing this, right? Aren't they? They're trying to show that he agreed to all of this stuff, and this clip wouldn't have taken them beyond after they made the amendment under Glanville. And this is a different judge, so this judge isn't privy to this interaction. So all the pieces are in play for the state to proceed in the under the guise of confusion. And also shout out to Flesh of the Gods. He said he's driving. So good to see you, Flesh of the Gods. He says, what up, what up, what up, cat in chat? This is a good one. We are doing we're looking in at Jim and Tiffany's deep dive on the Mounk Tounk mess. So good to have you here. Shout out to Flesh of the Gods, one of my favorite channels here on the YouTube. And I think you found some archival stuff, right? With Flesh of the Gods? Jim?
Have I?
Sorry.
I mean, I watched the channel. I don't know if I've
He pulls like so many interviews just out of the blue that people forget about.
I probably have. I mean, I just don't remember anything offhand.
Let's see. Let's see how Love does this.
7 of State's Exhibit 1AS.
Yes, ma'am.
Why didn't they cut this part?
Your Honor, at this time, actually, and Mr. Sledge, have you had an opportunity to review each and
That part, what she was about to do was do the one-by-one reading of the factual acknowledgements.
And then she was like, oh, we can just waive those, hopefully. She didn't want to read them out.
Nope.
Right? Well,
she did read them out, like, but not one by one.
Sorry.
No,
I'll say that's not entirely unusual, but in this context, it's like an eyebrow raiser. Because sometimes with plea hearings are like, yep, get through it. We already know. We can trust you guys enough. Let's just do this. But here, for her to be the one that stumbles over it, in the totality of the context surrounding the YSL trial, it's a little sus.
He was the only one of the 8 defendants in December 28th, or December of 22 to plead guilty who didn't do the one-by-one reading. He was the only one. So it kind of suggests that there was something unique about his factual acknowledgments that the state didn't want to look at too carefully.
Yeah, because they've loved pronouncing on television, like, these are all of the horrible things that we're getting convictions for. Like, it's a way for them to tout the job that they're doing to keep everything safe in the community. And to skip it is kind of like, why would we want to skip it when we're so big onto the cameras and our PR? So it's like,
I was thinking about Chase's interview where Bonnie kept going back and forth between whether it's safe or unsafe. Like 15 times in a row.
Oh,
like, this is the safest place. It's so terrible here, but it's safe. But you're going to get killed. But the kids are safe.
He was so calm. And he said, Fani said, don't listen to those out-of-town attorneys. And now I think of you. I know she was talking about Andrew Fleischman, I think, who had some thoughts over on X and gave a statement to 2 different papers. So I'm pretty sure that's exactly who she meant, was Andrew Fleischman, who has has overturned quite a few appeals. For one of them, the error was Love talking on pre-arrest silence, even though in that specific case, the defendant actually voluntarily went and spoke with police. She still made a comment on pre-arrest silence, which you're not supposed to do. And it was factually incorrect also. So Fani tried to get her little quip in about Andrew Fleischman, but I also thought of you, like, she doesn't even know this big old motion is going to come down and put some scrutiny on the shoulders of the same person she wrote this German Uber love letter about.
Oh my God.
One of my favorite moments was when we had this letter from Fani Willis praising Love for the job that she was doing. And Aaron's also got it here, the good recall here. You know, Whitaker wouldn't have been aware of this hearing because it was Judge Glanville at the time. And Aaron says, yet another reason why Bruce Harvey was correct that this trial should not have continued after Glanville's recusal. Sucks for the state because they ended up being the losers on that side of that decision, right? But it's still a huge gamble for the defendants. And then Brooklyn NYC says, when does the state have to reply? Is this just like a 31-day, 21-day window?
I don't know. They need to sharpen their crayons.
They're going to ask for time. They're going to ask for an extension of time to reply.
I regret saying that. I'm not sure, actually. I have no idea. I haven't even looked yet. I don't know any of this stuff. I'm just getting started. I don't know any of this law.
I feel like you'll meet deadlines, though. You will meet deadlines. It's them that probably is at risk of not meeting a deadline. So yeah. Let's see, because we didn't even get to the finagly part.
No, we can help stop.
Yes, ma'am.
As reflected on State's Exhibit 1AS, the current charges that you face are count 1, conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act, and count 30, possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm, OCGA 16-11-133. The negotiated sentence as outlined in State's 1AS is count 1, 15 years on probation, and count 30, sentencing withheld until years on probation, and count 30, sentencing withheld. This is not me, chat. On probation, and count 30, sentencing withheld until years on probation. And
this is the stream she's playing.
Skip forward 2 seconds.
Now, it's hard to see behind Law and Crime. Antonio Sledge is giggling. The time marker is 6 minutes, 40 seconds.
I can't believe this. I can't believe that happened.
The agreement is not captured. I'm going to object to skipping forward. I'll see.
Let's see.
Your Honor.
I'm not saying to skip anything substantially. I'm trying to see if they can skip over the part where it's just repeating itself.
Yes.
I love Max.
Do a squeak counter. Oh my God, all these famous video clips. They spend quite a bit. I wish they were showing the state while they did this. Doug is rolling his head, stretching his neck muscles. So they take all of this time, and then Hilton ends up pulling it up on her computer. And then
We're sharing
watch
through a different screen, and we're going to go ahead and pick up
On
that
these
640.
charges.
now.
Actually, look at the file name too. It's a different.
Oh, is this at the bottom? It says 1AS. Record something. Sledge exhibit 1AS.
Yeah, but
Recording of, maybe?
oh yeah.
But yeah, so they pull it up. It's watch. I'm going to have to stop it and read the way it's scrubbed because it's really tiny on the screen. But she's going to have the opportunity to scrub it backwards to where she left off and continue and capture all of it. She scrubs the little timer back and then she goes, oh, never mind, and jumps it forward again. So let's try to break that down.
At 640 where we stopped.
So she acknowledges 640 is where they stopped. She goes to 642, then to 632, then back to 642. So she chooses just to play it. And what she's skipping is the sentencing withheld. Oh. And just what are the
It
odds?
has complied with the special conditions outlined in section B as in boy, C as in Charlie, D as in Delta, F as in Frank, I as in Indigo of section 3 special conditions of sentence of this plea agreement. The state agrees that defendant shall be allowed to withdraw his guilty plea on count 30, and the state shall agree to null pros count 30. The special conditions of the sentence, as outlined in section 3, are that defendant shall abide in full by each and all of the terms of this negotiated agreement. Defendant's failure to abide by any term of this agreement shall constitute a violation of the agreement. Defendant shall testify truthfully about all matters relating to this case upon which he is questioned at any trial or judicial proceeding stemming from the facts alleged in this indictment. In accordance with testifying truthfully about all matters relating to this case, defendant acknowledges that each and all of the statements contained within the defendant's factual acknowledgments section of this agreement are true. Defendant shall testify truthfully about each statement contained within defendant's factual acknowledgments and any matters related to this case when asked to do so in any proceeding related to the facts alleged in this indictment. Defendant shall possess no guns unless his right to do so is restored. Defendant shall commit no criminal acts. Defendant shall submit to random drug screenings by the Department of Community Supervision and any agency designated by the court in this case. Should the defendant test positive for any Schedule 1, 2, or 3 drug, defendant shall within 30 days of said positive test undergo drug rehabilitation as designated by the court or the Department of Community Supervision and shall successfully complete said rehabilitation program. Defendant relinquishes any Fifth Amendment right related to any statement contained within defendant's factual acknowledgments contained within this plea agreement. Section 4, defendant's factual.
Here we go. Do you have a comment before we get to section 4?
No, I never thought about that. I just got a new idea.
Oh, there we go, chat. You got to do like well, what's permissible for you to do on your own stream. I'm not going to advise you to do anything that could get you in hot water, but it'd be great. These like stupid little specific things where it's like, here's a problem. Here's the representation made in court. Here's why it's a problem. I think would be so educational for people. Especially because you're learning it, so you're not taking it for granted because you're still. Yeah. So, but yeah, here we get into section 4, factual acknowledgments, and the fact that she's gonna.
Have you initialed each and all of the defendant's factual acknowledgments contained within section 4 of this document?
Yes, ma'am.
And is that initial AS your initial?
Yes, ma'am.
So this is where she gets it, is voluntary. He acknowledges all of them. And then at the end of the day, what's the problem? This is 1AS, and this is the rejected plea agreement. So at the end of the day, this shouldn't matter unless it was incorporated into the amended plea agreement. And that wasn't the case. This is not reincorporated into the amended plea agreement. We're missing it.
Yeah, and hold on, I need to pull up this one thing specifically. I just want to emphasize how little time that he had. Where is it? With the is it here? I don't know. I'll have to pull it up later. But at the most, I mean, the last version of the plea agreement was sent, I think, at like 3 o'clock on the 28th, the same day that he entered a guilty plea. So, I mean, it's not like he had a day to sleep, even one day, to go through it and decide whether to accept it. That's,
yeah, and if there were no other paper copies, he probably didn't have it in front of him to read. Like, I am such a I can listen to certain forums, but like if you ask me for movie quotes, I can remember more things from books than I can remember as quotes from a movie. It's just the way my brain works. I don't remember auditory as much as I remember what I read. And same thing, maybe that's not the same for everyone, but I don't think he had a piece of paper to sit there and mull over and go change by change.
Yeah, if you if you watch the full video on Law and Crime, Love had the copy when she at the start of the hearing. So it wasn't even like he could look at it.
Here,
like,
I have
at the start of the hearing.
I was gonna say I have the hearing open separately, and I think it'd be because I don't. Did you want to play any other parts of that day where she was presenting in court? I think.
I think this is fine.
This let me jump over and load this one up. Just the way that this stream ends. So.
Oh, okay, yeah.
This is the clip from Law and Crime. This is not being replayed within the trial. This is the stream that they published on December 28th, 2022. But it captures everything that we've seen up until the admin says, hey, there's a structural issue here.
Your Honor, with the court permit, the state a moment to confer with Mr. Wright and to ensure that we...
You got one several. You got one of couple. You just can't do it this way.
Yes.
You just can't do it this way. That's Glanville.
Your Honor.
I'll recess.
Thank you, Your Honor.
And then you can see this is the end of the stream. Flaws. And worst of all, I mean, again, Adrian Love is the one presenting this clip in the YSL trial on day 124. She knew that stuff took place after the clip that she was showing, and yet she showed it anyway when the court had questions about the factual acknowledgments actually being agreed to, because Sledge was on the stand saying, I didn't really agree to that. I don't know if that's what I agreed to. And fast forward, they end up trying to revoke his probation and successfully do so because Whitaker decides that his questions on the stand, his testimony is akin to perjury. But then if we rewind this, if Whitaker knew better, the first question would be, Love, how are you trying to impeach this witness using an agreement that was rejected to impeach a witness?
Yeah. If you want to go back to the PDF real quick on page 579, we can compare it to where we are in the video just to see how much was
579. And let me drop this link in the chat again. It is in the description as well, but you guys know we said this is like 600 pages, but the transcript is here. Oh, Mr. Chamberlain.
Go to the bottom of the page, actually.
This page specifically?
Yeah, so that's where we left off in the video, basically.
Okay, the minute to confer. So we're on 28 of the transcript.
Yeah. So all of that stuff
so 36
was not in the video.
And obviously private discussions wouldn't be transcribed here either.
Yeah, that's fine. But
yeah, so there you go.
Yes, so if you look at, let me see, go down. Actually, no, yeah, the bottom of this page. This is the new plea agreement. That was what I called the adopted plea agreement or accepted plea agreement. In the motion, what the state recommends, this count, the defendant be sentenced to 15 years on count 30. That's the sentencing is not being withheld. It's not sentencing withheld until the completion of the initial trial of this case. And so this is why the written plea agreement is irreconcilable with the sentence.
Well,
So-
and then the disposition ends up having that weird wording where they just cut out the
Yeah.
sentencing withheld and it reads like an incomplete sentence.
Yeah.
It reads
Because it is
as,
one.
not like, as, not like. And same thing this part here too. She says, I believe that the plea agreement that is states Exhibit 1AS said that if the defendant violates any term of this agreement, that he would be subject to serving up to 35 years in prison, and that should be 30 as opposed to 35 years. So it's like, you were about to accept this and push this through until Chamberlain put it out. So how is even the verbal acknowledgement truly
It is so
an
wrong.
understanding? Like
30 isn't right either. That's the crazy thing.
Yeah, and this is still wrong. And it ends up in the future, we have part of it vacated because it's void. So, I mean, it was wrong and they were going to accept it, first of all, until Chamberlain was a little bit of an obstacle. And then we were still wrong, but we got it through. We got it passed. And then it was 2 years later, it's vacated because Jim and Tiffany come along and say, what are you guys doing? What are you guys doing? And this is the thing, this would be completely hidden otherwise, because who would go and have seen this? This was not in a law and crime stream.
Oh, God. I've gotten in so many fights on Twitter about people who say they've watched the entire law and crime video and they say that I'm wrong. Oh, God, it gets me so bad.
Well, in any case, if there is another clip, then Love, it's worse for Love because she would have had the opportunity to find it, reference it, and put up the actual changes in the terms. And not for nothing, but it's an acknowledgement that there is a different plea than 1AS, and she never should have been able to admit that as an exhibit. I just don't understand that. But how would anybody else know differently in that room besides Love? Love would be the person that would have that knowledge. So.
Yeah. I'm not going to say something, but yeah, it's never mind.
Oh my gosh. And then Mr. Wright says it's okay. They're asking briefly anything on behalf of Mr. Sledge. And now he's starting to advocate a little. Well, and reiterating, he just wants to go home. So imagine you think you're about to go home and then the judge and the judge's assistant are like, you just can't do it this way. And you're already wanting to go home. I feel like in that moment, the pressure to just accept it so you can go home right now would be blinding any person to understanding what the changes were, let alone the fact that you're not really giving him the time to look things over and think about it. So what a rough position to be in.
I will say that we haven't even, the biggest problem with the plea agreement, we haven't even briefed yet.
Well, there you go, Chad.
There's an even bigger problem.
Subscribe to Jim, Happily Angry Lawyer, on YouTube. I'm going to drop that link in the chat.
I will not be discussing that on YouTube, but at least until after.
Yeah, later.
But there are. Like, I mean, I've said this before. We've used like 20% of what we have so far. The worst things are still yet to come.
And I wouldn't even be surprised if, like, the little bit of stuff that you have argued, if someone else is like, hey, there's also this other issue, and you're going to just start, that crowdsourcing will eventually start to kick in, where people are like, hey, I was reading this case I was looking at and saw a similar issue. And then here we go. We have this whole snowball again of here's the whole pattern emerging of the same.
I bet that's what Max felt like when everyone was like, the brake lights are pumping. And he's probably known it. But it's like, once the crowd gets going.
Yeah, and I would anything that Hogan was on, I'd say they need to revisit. You guys know my thoughts on Viverito.
I have, yeah.
I'll leave it. Well, we can leave it to my thoughts. We don't need to extend that on anyone else on the stream right now. Just a whole mess, a whole entire mess. But guys, yeah, it's just crazy because there's no excuse for Love to not know that a totally different thing was submitted. There's no way. This isn't just like something that is a blip because it's so insignificant you just forget that it happened. But yet she made more than one representation using 1AS as an exhibit in the YSL trial as if this never took place.
And I mean, think about that. Never mind. You're right.
On that subject, huge shout out to Kay Schmidt, one of my favorite people. catching K. Schmidt sometimes in chats for other trials, but it's always nice to see a familiar name back in the chat when we're talking about YSL. As horrible as some of the stuff with YSL was, it was a part of my daily living experience. Like, I feel like I'm friends with you because of YSL. Like look at the names. I was nervous about the next stream that I did when, if you guys got on YouTube this weekend, YouTube was messed up and it was using the @names instead of the username display name that you set for yourself. And I was like, oh my gosh, what if I get on stream and I don't recognize people's usernames and I mess things up? I was so nervous about it, because being able to have met you guys, even if I've never seen your face, I've never had you up on a stream, like, I just think it's such an incredible thing that all the horrible things that happened in this trial, people came together and raised awareness. And I really think there's pressure on Fulton County because of people on social media that live in the area and beyond. It's not even limited to locals. And it's just incredible.
I love teasing Classy Beats about that. Like, way to go down in Fulton County, Classy.
Oh yeah, I always forget he is there.
Yeah.
So thank you so much, Kate Schmidt. It's great to see you. Thank you so much for dropping gifted subs. You've made so many people green over the year since, we all met each other. So always your support is appreciated here, and it's good to see you. It's good to see you for some YSL content. So we don't know the exact response, but if you requested a hearing, I am like 7 hours away. It can be way further with bad traffic, but I would totally go up there and sit in the courtroom for that. Unless you wouldn't.
Yeah.
Would you not want?
That's fine.
Guys, we might do a trip to Atlanta. We'll make.
Yeah, I did a trip to Atlanta once. Still mad about that.
Yeah, nobody wanted to meet with you.
Yeah.
Yeah. Well, now maybe this time they'll want to deal with it before it goes any further. Chat, let me ask Chat a question. Does anybody get the impression, if you didn't hear Jim mention it, as we were reading this, or you guys on your own, have you guys felt like there were still other issues? And the reason I'm asking the chat for the opinion is the state, who is in a prime position to be aware if there's more issues to be raised, if they see the persistence of Jim and Tiffany, they didn't just give up on vacating the sentence. They're returning, hey, there's still an issue here. And here's some more additional arguments. If they're smart, they would start to realize that this isn't the end of the road. This is probably the beginning of the yarn unraveling the ball. So it would, to me, they should want to meet with you and figure some resolution out. Ideally, a resolution that let's get him out. Let's get Mounk Tounk out. Let's at least get him out of solitary. Like, that's just crazy.
Yeah, they had. Never mind. Yeah, I'm looking at my list of errors right now. It's pretty long. There's definitely more. There were multiple more just in the plea hearing. So 1, 2, like, there are at least 5 or 6 other reversible errors just in the plea hearing that I'm looking at.
Apply for Rule 22. Guys, you're going to make fun of my camera skills. You know how we'd be like, camera, turn, cameraman, show that part of the screen. My camera's going to be like, I will be a mess. But that would be awesome. And that seems pretty simple to do. It seems like you can do that like the day before and they acknowledge it by the day of. So
I don't even remember some of these mistakes. I forgot about.
Are you looking through a list right now? Oh my goodness.
That's funny.
Yeah, Aaron, everybody come to Atlanta. Everybody come to Atlanta. That'd be fun. We got to figure out a date. Can you imagine? I mean, I would just love for people to be in the courtroom for that. I mean, we didn't have, and this is more of a message to Judge Whitaker than to the state on this particular attendance. But you did her resentencing. She just wrote down and filed the order.
Yeah.
And there wasn't any hearing. Nobody was present. And that's just weird to me. And I'm glad that there's case law that specifies you can't do that for resentencing, but common sense would suggest resentencing is sentencing.
Yeah.
It should be the same either way, but it's helpful to have the explicit case law.
Yeah.
So it's just crazy. All right. So anything else on your chest that you want to get off your chest, Jim?
That I want to, yeah. That I can, not as much.
Yeah.
Someday.
Well, that was a bad question on my part. My bad.
Let me see if there's anything here. Yeah, I mean, I guess that's, I don't know, we've said it all. I mean, the fact that there are no special, that's the thing that still blows my mind when I think about it, is how much time was spent on 1AS, how many times, or 444 Yankee, alternatively, it's the same thing.
It makes more sense in retrospect. During the trial, I'm like, why are we going through these lengths? Either get through it or not, or maybe don't even bother impeaching him. Because at the same time, I think it's pretty reasonable. Somebody took a plea and they don't want to answer honestly. I don't think that that's hard for people to consider being a possibility. But the lengths that she was going through to introduce certain texts and then not wanting to introduce certain others, like the email exchanges, or have Ashley Merchant come in, it's just, now in retrospect with this context, to me, it just screams, well, this is the reason why. She wanted to fight and insist that there were 10 reasons why she was telling the truth, that these acknowledgments were part of his accepted amended plea agreement and conditions in the disposition.
Yeah.
Without anyone actually checking.
Yeah. Now that you mention it, that's the last thing I want to get off my chest. This is one more big picture thing. Is the state had an opportunity to let Antonio go, and we wouldn't have filed any motions. They had that opportunity, and he wouldn't have said anything. And if you think about all the things that were said about him at the revocation hearing, I don't know if I'm allowed to even say what the crimes that he was accused of are, but they're really bad, heinous.
Yeah, it was like aggravated sexual battery.
It was aggravated sexual battery, attempted aggravated sexual battery. And he was willing to just let that go uncorrected, just for the chance to go home. And think about it, he could have lied and repeated what the state wanted him to, but he went to prison to not lie. And I think that's one of the things that is admirable about what he did, is he's been sitting in solitary confinement for 8 months, and he could have avoided all this, and he could have avoided the reputational harm by just repeating and parroting what the state wanted him to say.
There were tens of thousands of people watching that revocation hearing.
Yeah, I mean, the videos on YouTube, there are millions of views on YouTube videos.
Like crazy.
And people believe that. I mean, they do. But he just wanted to I was hoping to get him out by May. He had a couple family things he wanted to do in May that were very important to him. But that was taken from him. And he's never going to get those moments back. But he's taken a much stronger stand for the truth than the state has in this case or in any other case. Has it been 8 months? Did I count that wrong? Yeah.
Well, I was just thinking, it feels like it's sped by on our end of it, but imagine being on the other side where you're in custody, and that's 8 months that you don't 8 months flew by for me because I'm able to live my life. I'm working all the time. I have things passing the time. I can go to my kitchen and cook something if I want to. I can cover a case casually because something pisses me off, but there's really not a direct repercussion of somebody's misconduct other than it just really pisses me off and gets under my skin, and I just don't like it.
Yeah.
I'm not losing my freedom. It's a choice for me to do everything I'm doing in the last 8 months. And it's just such a weird thing to think time is flying. And then at the flip side, time is flying in relation to Mounk Tounk not having control over his own time.
Yeah, I actually was literally flying during the revocation hearing. And right at the end, we started to land and the Wi-Fi cut out. and I had to like wait for the plane to get to the terminal, so I was so mad. But yeah, and I mean, prisons are dangerous. They've been in gang war in Georgia prisons for the last week or so, or maybe 10 days. They're incredibly dangerous. It's a bad place to be. I mean, it always is. But.
I was going to say, and like, you know, somebody's in solitary and maybe in theory it should be protective in some way or form. Can we even have faith that the facilities in Fulton County are designed and kept up for that to be the actual reality? So I think there's much to be desired there.
Okay. Actually, like one last thing.
Yeah.
Which is, normally I wouldn't be this like, I wouldn't talk this much publicly about a client's case. This is abnormal. But I guess defending his name and his reputation is also part of this case in a way that it typically isn't. So I
wasn't he running a company?
Yeah. I hope it. Sorry, I'm not going to say that, but it was a setback. It was a major setback. But yeah, he was running a company. He was shot 8 times and he got a settlement. He nearly died, spent months in the hospital, and he took the settlement money and used it to start a shipping business. He had drove a truck. I've seen the paperwork. It was all very boring and legitimate. And yeah, I mean, I'm assuming that that's detrimental to his business, just disappearing for, I don't know how long it'll be, 8 months, 10 months.
Yeah, 8 months. And like, it's not like, oh, you go in and answer emails for me. Well, I don't know how to manage logistics. So you can't just like have someone volunteer on the outside to bear the burden if they don't even know exactly the skill set or work to do it. Yeah. So yeah, that's crazy. That I think I remember that detail because it's just like, dang, like it's so hard to get a business off the ground running, and then someone playing around because they can't do things the right way just rips the rug out from under your feet. And what's the point of a criminal justice system if we're supposed to, you know, shape people back into productive members of society? Well, when they're being productive members of society, this is what we do. We revoke 5 years of their probation because they did something akin to perjury when really there's really no acknowledgement in place that he was supposed to abide by.
Okay, my last thing.
I'm gonna stop because I keep prompting you to keep going.
Okay, look at factual acknowledgement number 6. I'll tell you what this was on.
Is it searchable? Well, I don't know how many. There's probably there's way too many of those. What exhibit?
Let's see, page 547. Okay, first of all, Paramore is ridiculous.
Oh yeah, I remember that. Oh wait, is that further up? Paramore. Or is it this one?
What is it? That's not important though. That's just a style thing. Number 6.
Isn't that actually up for dispute? Because Paramore might not necessarily mean girlfriend.
Ex-Paramore definitely doesn't mean girlfriend.
Yeah.
And why do you, if you have to explain it, just say girlfriend? What are you doing? Anyway, so number 6, defendant admitted committing. He didn't though. That's not true. And the state knows that's not true. That's not an acknowledge. I mean, they know that never happened. And they know that. They were there.
So wait, was this part of the Alford plea for the Adele Drive thing?
Yeah.
So she misrepresented the Alford plea like a loon during the trial, but it's also incorporated as a misrepresentation into the now void, like the never accepted plea agreement that she continued to rely on. This is just so circular. It's just like a dumpster fire that keeps reigniting itself.
Yeah, and there's one other one.
I would not have even. And I guess in part because I wouldn't have known that this was tied to the specific activity in the Alford plea. Like That's a lot of connections to make to piece that error
Or-
together.
Like
As
number
an
13.
outsider, they should be aware because Love was part of that trial. So
Yeah,
how does she
like
not know?
Yeah. And like number 13, that's just not even like a factual statement. That's like a promise.
Yeah, defendant can. Oh yeah, I hated this. This was in Slug's plea agreement too. Tick. Defendant cannot truthfully assert that the persons charged in this indictment with the murder of Donovan Thomas are not guilty. This is, to me, this is putting the stamp that you can lie. You can lie on the stand and you can make things up and you can falsely accuse somebody because we're telling you cannot truthfully assert.
Yeah. And like the second part, defendant will make no attempt at trial. That's a promise. That's a future event. That's not a factual statement at all. That's just not a fact.
It's a directive. This is the special conditions that she didn't want to actually incorporate into a special condition because it would look like complete BS to require somebody. You can't truthfully assert something even if it's true.
Yeah. I'm sorry, I'm just getting worked up again. Okay, I'll be done now.
Oh, is one of these the hold on now. Is one of these one of these? The Mounk Tounk baggy shot? Let me move this comment. I have this just saying, yeah, 151. There we go. The gas station at 151 Cleveland Avenue, Atlanta, Georgia is one of multiple locations where YSL associates sell drugs and do not allow other gangs to operate. The infamous tag.
I've watched body-worn camera of 151 Cleveland Avenue. There's a chicken shop there. There's another. It's not just a gas station. It's being undersold. Okay.
It's an all-in-one.
Yeah, I hear the chicken's good.
I love that. I love that.
I'm gonna check it out when I go there.
Well, let's see. We've got, hey, Nana Banana's joining in here right as we're wrapping up. Yeah, Keisha says moving reckless due to qualified immunity. I mean, that's to me a super huge problem and not limited to Fulton County, but definitely a big factor. And then if the judges aren't sharp, stuff isn't going to get corrected. And then who's going to advocate for you after you're convicted? Yeah, Keisha says, how can the state sleep at night? I really don't think any of this bothers anybody in that. I think there are prosecutors out there that are passionate about what they do and they are not out there just to get convictions. But for the set of characters that we've seen related to the YSL indictment, I don't know how they sleep at night. I don't know.
Atkins is cool.
So nothing is beyond reach for Atkins.
I like Atkins.
I was reducing my media assets, but I did keep this one. I think I had the cartoon somewhere. I don't know where it is. I've got the Viverito. We've got Cart Guy 1 and 2.
I don't even remember that guy.
I remember this guy. I didn't remember this guy. This guy was new when we saw him. Yeah, we've got all the relics. We've got Happy Page. Happy Page should hold a hearing. Oh my goodness. Let's see. Yeah, and Sean says if you fix this, it's tons of work. You could make millions. And guys, I know, I put all of Jim's Cash App stuff in the banner. Please use it.
You have a squeak counter
for Mounk Tounk. What do I have?
You put the squeak counter in again at the bottom.
Oh yeah, because there was a squeak in the clip we played.
Sorry, I didn't mean to interrupt. I just noticed that.
Yeah, there was a loud squeak in that clip that we played.
Yeah.
I couldn't not include it. But there's more than one case where he's noticed issues. And I mean, I think the number one way to support advocacy, there's limited things that I can do to go into a courtroom and make a filing on somebody else's behalf. I'm not a licensed attorney. And even a civil issue, I don't have standing. I can't just go and represent somebody. I can't just go file a claim on behalf of somebody else, despite what some attorneys are doing in some other civil cases that are high profile and known right now. But we've got, and Jim, I think you're doing like above and beyond what I've really seen many other people do, Tiffany included. But there are other advocates. And one of the ways is when they are doing something pro bono, support it. It doesn't need to be financial support. It could be, hey, next time there's a issue that's pissing people off, be like, have you also heard about this other thing going on? It's part of the YSL trial, but it's not done. There's this Antonio Sledge, Mounk Tounk. Go pay that attention, because that's how you get traction. That's how you start to get the journalists to pay attention. And then once the journalists are paying attention, it's exposed to an audience that's no longer the YouTube side of things. It's the people that sit on TV, they go out and vote, and then that could finally move the needle to put some pressure on.
Yeah.
And additionally, for those that live in Fulton County, I heard that there's proposals now by the commission to raise property taxes 12% after I think like six months ago, appraised home values went up like almost 30%. So imagine the tax influx if they're able to raise tax rates after tax appraiser just said homes are worth 30% more, while home values are actually dropping right now as we enter a buyer's market. Fulton County is making sure they can go get some property tax money.
Yeah,
So,
that's to Sean's point. It's hard to ask people for money when they're like in prison, and I don't know. It's tough. I guess I'll have to get used to it eventually. But like there's one case, and it's actually my first non-Atlanta case that I've been thinking about taking, and it's a guy and somebody else confessed to a murder, but he was convicted. And I mean, I don't know if his family's like what their financial situation is. I know it's not like they can afford, well into the 6 figures of appellate fees. Like if I were billing at my rate for my last law firm rate, like Mounk Tounk, it would be in well over $1 million by now. And it just doesn't feel right to ask for money from people who already had so much taken from them.
See, that's a weapon that prosecutors wield. They know nobody's going to go to the lengths to fight this stuff. So they can do it over and over and over. And even if someone, raises a question about it, that's not really a challenge. It's not a meaningful challenge for people to say like, this makes me mad. So this is critically important. Another way, you guys, make sure you're subscribing. Like, I don't like to, I love the mods in the chat. You guys are always reminding people to hit the like button, and it is helpful stuff. It is weird to sit here and say, hit the like button and subscribe, but it's so much easier for me to do for somebody else. So like in the chat is Jim's YouTube channel. I'm fine saying go like his stuff, go subscribe to him, because as he covers and educates us and raises awareness, if he can get some YouTube ad revenue money in the process, that would just be awesome, because I don't think you'll feel bad. I don't think you'll feel bad about passively making in some money from stuff like that. And that's really one of the ways that this could support long-term. One of my favorite legal minds is Ian Runkle, and I'm sure half the chat knows Ian Runkle, but his goal is to make enough money through YouTube that he can do pro bono work and not have to charge people. And I just think that that's just such a great thing to do. So full circle, anything that we can do to help raise awareness, support, help you guys. If you know of somebody that would be a paying client or is a organization that gives out, that finances people and hires people to do this type of work, I mean, share it around, because maybe it'd be something is up Jim's alley or somebody else that we know.
I just remember, I'm not even licensed in Georgia.
Well, that's why I was saying like somebody else.
Yeah.
I think we could fund your your bar exam. It's not a reciprocity state.
California isn't. It's one of two. But I don't know. I'll probably do it. I think the next registration deadline's October.
Well, at least you'd be taking the Georgia one and not whatever's going on with the issues with California's bar exam.
It's so stupid.
Yeah.
My laptop died during my bar exam. I had to like switch from laptop to handwritten like halfway through. That was.
I picture you handwriting fine. I bet you were fine. It's just nerve-wracking because it's nerve-wracking in the moment.
Yeah.
All right, you guys, any final thoughts? I've got one while we're on the topic of of law. I've been waiting on this. I hope Peter's still here. Peter says, okay, Kat, get studying for the bar. You would be a fine attorney. I will help. I've thought about it just for the sake of continuing education and understanding more. But at the same time, I feel like, for example, people ask, can you cover this case? And it ends up being a self-defense case. And these states all have different versions, even the burden of proof when you put forth an affirmative defense. States have different rules for affirmative defenses. For example, in Ohio, an affirmative defense, if you want to put one forward, there is a greater burden of proof on the defense. Whereas something like Florida, and I think New York is the same way, you have the burden of proof to convince a judge to allow you to rely on an affirmative defense, or perhaps present some evidence on the record at trial that would warrant, and it could be a minimal, that would warrant a justification charge for jury instructions. But otherwise, it's the prosecution's burden of proof to prove that the actions were not justified in self-defense or defense of others. But that's not the case in all states. And I would love to spend my time like learning like state by state and picking up all this. It's not trivial knowledge, but it's like those smaller details, the nuanced details, and just being able to raise awareness. So Peter, I have thought about doing something like this for the sake of it, like just for the education. But I still think there's so much more to learn than what's contained in a bar exam. Yeah. So, but big thank you to Peter Ortiz. Any final thoughts or words here for Jim? YP Kamshik says, I heard the bar in GA is easy. I hope so, and honestly, that makes some sense. That kind of makes sense.
Oh God, what am I pale?
No.
And
that's publicly published, right? Isn't that?
Yeah.
So we would all know the pressure's on. The pressure's on. I don't think
delete
it's a
my
big
accounts.
deal. You delete everything. You have to change your name. You'd come back as Rim Joe Bouchard. It's a horrible switch. Don't go with that name. Oh my goodness.
Oh God.
Thank you for the love, Keisha. And Jeannie, yes, Jeannie says, I haven't seen you in months. Hope Mounk Tounk is able to get out. I felt love was so wrong. It made me feel so bad. So thanks for popping in, Jeannie. The feeling is super mutual.
Yeah.
Yeah, and Bama Rose, another great supporter of, transparency in courtrooms. Bama Rose provided a bunch of documents when we were trying to look at the Rodalius Ryan and Damon Blaylock appeals. She pulled up some of the other stuff that wasn't just on the court website. So huge shout out to Bama Rose.
That case is upsetting.
Another Hogan case. But yeah, well, if we get this date, we'll talk about it. It'd have to be a community post, but my brother lives in Atlanta, you guys, so it'd be an excuse for me to go up there. Ever since I started following Lead Attorney on YouTube, and now Tiffany too, I've always wanted to go to that stupid Brazilian steakhouse Fogo, I think it is, that he always talks about. I've always just wanted to go because he talks about it so much. So I don't know if that would be the restaurant of choice, but definitely some food in the picture would be super awesome.
Yeah, for sure.
We got GG's in the chat here for Jim. Yeah, maybe a paralegal exam. That might help me get access to more. Like sometimes I can't access online records, like case file stuff without credentials.
Yeah.
David, don't take Hilton's class if I become an attorney. I would take
so
it
awkward.
to report back. I'd report back on what it was like. And then we have an update. Aaron says Lil Rod's habeas should be getting filed soon. I think the deadline is October of this year. So so there we go. That's one to look out for because October is going to be here before we know it.
Do you know who's doing it?
Yeah, Aaron, do you know who's doing it?
Is it Kyle? It might be Kyle.
Kyle Winchester, guys. So look for that name if you want to look for another advocate that's, fighting the fight. And I wouldn't be surprised if we eventually see your name on. You're just always. I think it'd be kind of great if you just were like forever pro hoc vice, but just kept entering in on Fulton County cases.
I was going to say, I'm being tweets. It should be like win or go home. So if I win, I mean, I did win, but if I were to win my first motion, I should get the loser's license.
Oh, winner takes
Make
all.
things interesting. Put some skin in, you know, have some skin in the game.
Yeah, that'd be good. That'd take attorney sparring to another level. Okay, Dylan McConnell. And Bobby says, what do I think is going to happen with Diddy? I mean, I don't know. I don't really think the jury questions were that interesting. I know I thought the jury questions in Karen Reed's trial were very interesting. They were pretty specific in what they were asking. I don't think the jury questions today in the Diddy trial were, well, I guess one of them was about transport of drugs. So it seems like they're weighing the issue of who procured and possibly transported the drugs that were involved. And it seems like they're probably arguing that issue. But there was another jury question that was more like a letter where the jurors were saying, hey, juror 25 doesn't want to play ball. Something to that effect. But then they just went back and deliberated, and they continued deliberating off the instructions to try to work it out. So that was resolved. No major. We don't have a voir dire. We don't have a juror getting kicked off and an alternate being brought in. And I don't know. I don't really have a prediction on the Diddy trial.
Yeah, I have no idea.
I think that's one of those cases where expect it to go any which way. And until the jury decides, there's really no sense in trying to guess what they'll decide.
Yeah. I mean, more generally, it seems like it's a much closer case than it was portrayed at the outset.
I agree. I mean, I thought it was some slam dunk where they had like secret passageways of people being trafficked, but at the same time, I mean, some of the laws like the Mann Act, I didn't really realize that the Mann Act was kind of as loose as it is. Where if you're flying out with the intent, even if it's completely consensual, someone could prosecute you for getting flued out or for flying someone out. Yeah. That I wasn't really aware of. And, you know, I do always wonder, you know, does an attorney like Brian Steele, does he see an issue like that and he sees an opportunity to go, this is stupid, it shouldn't work this way. And by jumping in on a case, he can fight that. Huh?
I think he definitely did. It was a, what's it called when you have prior transaction? Basically, when you can use prior incidents as evidence of a bent of mind or inclination to commit a specific crime.
Wait, not like penchant? Like 404?
Like similar transaction.
Oh,
like similar transaction. There was the prosecutors were trying to get in a bunch of similar transaction cases, and then Steele joined like the next day.
Yeah, it was like, that's why it was interesting to me the time that he joined. And I still think it's interesting. Most people didn't realize Nicole Westmoreland joined up until she's crossing Brianna Bongolan. And they're like, what? Nicole Westmoreland's up there? And the judge gave her kudos. I think I'm Not a Lawyer, but Mel had posted a transcript of the judge wondering why defense was objecting. Like, your attorney just had like a Perry Mason moment, essentially. Why would you object? It couldn't have gone any better for you guys. And that was kudos to Nicole Westmoreland. So
I've been stalking Dylan McConnell's LinkedIn page. He's like, he graduated law school like 1 year before I did.
That's another one to watch. So Dylan McConnell.
Yeah.
And Aaron, you're so speedy. Aaron is so speedy looking things up. It's just like an incredible thing. So it's like super nice that you go and look up this stuff. So thank you for that. But it's also like the speed of which that you do it is also applaudable in its own way. Oh, shout out to STS. Nice number choice. I love this. STS sent $69 on PayPal to JamesRobichaud207@gmail.com. What a wonderful number choice there. I love that very much. That is such a good one. Oh, I love that. So big thank you there.
Trakisha sent some money earlier, by the way. I meant to thank her.
Isn't that hard? There's been times where I've gotten off a stream and I feel like the worst because when I get off the stream and check my phone. I can't do it while I'm on stream.
Yeah.
And then I'm like, oh, and I'm like, on Cash App, you can't, like, you gotta like react to it. You can't just be like, oh, I'm so sorry, I missed this thing, I wasn't paying attention. You just send a heart, and it feels kind of like cold and heartless, and it's. But I love and appreciate you guys, and I'm sorry for anyone that's ever sent me a Cash App and I didn't see it till after. Trakeisha's heading out coincidentally, so have a good one, Trakeisha. We're gonna wrap this up. Aaron Smart having a cheat sheet with case numbers to look up. Love that. It's necessary. With that being said, you guys, do you have any streams coming up that you want to?
I have a list of stuff. I kind of want to cover one of Andrew's cases, actually. The one he just won last week.
Yeah, that'd be great.
There's actually another similar transaction because basically the Supreme Court said they have to be more similar than this. I think that's what it was. But
yeah, so like real quick on that, guy was there was a what was alleged by the state to be an armed robbery that turned murder with the disposal of the body, and the car was set on fire to dispose of the body. They pulled a different transaction that wasn't even arrested and prosecuted, where the same defendant, they found a statement given by a complaining witness back in 2011 of an alleged armed robbery, and they end up allowing that to be introduced at trial. And in my opinion, it's exactly what 404B is supposed to prevent, but it was allowed at trial, and now it's overturned. That's there's going to be a retrial if they decide to. It's not, just vacated entirely. But yeah, to say that a robbery is the same, a robbery that wasn't even a conviction, they just have a witness come in and say that they're pretty sure that this person robbed them back in 2011. To compare that to
robbery.
Huh?
It's like not even a similar robbery. I think it was like in an apartment versus like, I can't remember what it was, but it was like completely different.
Yeah, but it's like to jump the leap to say that someone's going to take someone in a car and then burn the car and burn the bodies, kill the person, is just a different type of.
Yeah.
It's 8 years apart. So that would be a great one to cover, you guys. So when we said Andrew, that's Andrew Fleischman. That is a criminal defense, typically working in the appellate space in Georgia. Lots of great work that he's done.
Or Kyle's Darren Mills case, the one he just won. When that 2 weeks ago, 3 weeks ago? No, it was more.
I think it was like a month ago.
Yeah, it was. That's another one that I'd like to cover.
Okay, and Stop Cop Street trial starting Monday. Now
I have thoughts on that one.
Yeah, you should do a stream on that. I was gonna say I haven't seen quite as much. Like when I see a video commenting on it, it's usually like a news report and they do a blip on a daily update. A lot more of that coverage is in like investigative journalism through publications or over on X. I haven't seen quite as much YouTube.
I started to make a video and I got so worked up and annoyed by the indictment that I keep having to delete it because I say something I can't. The grand jury indictment, they don't have the grand jurors. They forgot the grand jurors. They already had to vacate or dismiss like 15 charges because they were too void or too big. It's a mess, and I know that there are defendants who are clearly innocent, not guilty, like on like video evidence innocent. But there's just so many that they can't administer the case.
Crazy. So another thing that Fulton County is expending their resources on. So
yeah. That was the state, actually. That's the state. That's the attorney general.
Oh, okay. That's even kind of worse, I'd say.
It has flavors. It has some of the same themes that you would expect.
Yeah, Keisha says just dismantle the system. So there is another attorney, potentially criminal. You guys know the story of the Killdozer. If you don't know the story of the Killdozer, look up the Killdozer. Definitely a good Wikipedia read. He always just says, whenever he talks about the YSL trial, just bulldoze the entire courthouse, just bulldoze the whole thing. And Keisha's like, dismantle the system. And it's just kind of like, why not?
There's some truth to that. Like, it's clearly a training thing. That was one of the interesting things with the YSL trial, is you could kind of see attorneys pick up habits from the start to the finish. And some of them weren't good.
Yep.
They were good habits.
Okay, and Aaron's also saying they dropped all of the money laundering charges, but still charged all 61 with violating the Georgia RICO Act. All 61. Gosh.
I think Max is on that case too, unless it got dismissed. But who else? There are a couple of names, a couple of familiar names.
Crazy. I will be following that one. I won't be doing streams of that. But anytime I see coverage of it, I try to at least stop and see what's going on. And that's the kind of thing, like a poor jury going through having to keep 61 names straight.
Yeah. I mean, they did break it up. There could be like 10 trials or something.
Oh my God.
Much more separate.
I mean, maybe they'll do like a surprise where they just offer a bunch of pleas, and I don't want that to be the case, right? Because I feel like if they follow what we've seen in the county level, I wouldn't really love the pleas either. But who knows? Yeah. No, Aaron says, let me pull up my spreadsheet. No, we're winding this down. Make Jim do a stream on it. I think that would be a good one to do, even just starting with the indictment.
It's so bad.
Updates moving forward.
Hold on, I'm gonna open it right now. Let's do this.
Oh my God. No, you should do your own stream, and we could tell people to watch on your channel, because we've got to get you. I think
I'll do it tomorrow.
Like, guys, tomorrow.
What time should I do it tomorrow? Same time tomorrow?
Well,
I don't know why.
When did we start this? Like 6? Yeah, chat.
6
Jerome
o'clock
Street
tomorrow.
enter in the building. Yeah, but that'd be like 3 your time, right?
Yeah. I'm sorry, I'm just opening it up right now. I'm not going to read it, but
Flesh of the Gods said he'll do Cop City also if they don't sabotage the stream like they did the pre-hearings. So, and you guys know the drill with Flesh of the Gods. That would be awesome. Because I guarantee you we're going to have animations come out of that too, that Flesh of the Gods will create.
Because they showed the jury in day 1 of the YSL trial, didn't they? Or it was like one of the first days. They accidentally showed a couple jurors. Imagine if they'd canceled the video stream in that one.
Look at this list.
Brian,
Max Sharp, Bruce Harvey, Kristen Wright Nove, Donald Franklin Samuel, Durante Partridge, Josh Schiffer, Brian Tevis, Sean Hoover, and YSL Jimenez. So that's going to be a monstrous team. And honestly, with like Josh, I hope that gets. He's court TV, right? Not law and crime. I hope that gets more eyeballs on it.
Yeah, Suzanne Tevis too, I think.
All right, so Mary just subscribed. Keisha says 7 p.m. We all want to come hang out over on Jim's channel tomorrow to get the rundown on the Cop City indictment. So we'll get to it.
It's so stupid. I hate it so much.
Well, don't look at it now, because you'll talk yourself out of it. You have to just start the stream, and then you'll be stuck with us.
Okay, I'm not going to. Okay, all right.
Oh, okay. So hold on. Wait, let me get the link for the drive link again. YP Chic, you mean the filing, right? I'm dropping that in the chat for you. There's an AI summary on my sidebar. It says, this document is a motion to vacate void sentence filed by Antonio Sledge's counsel. It's doing a good job. It's doing a good job. They bullet pointed increased sentence on count 1 for double jeopardy issues, package deal plea agreement, void 5-year probation revocation. They did a pretty good bullet point there. I'm proud of them. We should tell Tyrone Blackburn to use Google's AI and not whatever he was using.
He just needs to stop doing everything that he's doing.
Guys, that is something I'm going to be following. You guys know I love attorneys behaving badly. So if I get a Tyrone Blackburn update, now that he's been asked to show cause for making up case law and making up quotes from the judge from the very case that he's submitting motions in. Yeah, not a smart thing to do. So Huge shout out, Flesh of the Gods, making someone green before we wrap it up here. He said one more is going to be green today. So big thank you, Flesh of the Gods. Again, Cop City. I would hope there would be a stream for that. There's got to be so much media fighting for press access there that if it's denied, it's going to be an uproar. So that means Flesh of the Gods would have a way to cover it. And everyone, thank you so much for tuning in. We will wrap this up and see you guys tomorrow over on Jim's channel. Bye, guys.
Yeah.
Thank
Bye,
you,
everybody.
Jim.
Yeah, thanks.